the North Carolina Utilities Commission. And with me today are Commissioners Tanola D. Brown Bland, Daniel G. Clodfelter, Kimberly W. Duffley, Floyd B. McKissick Jr., Jeffrey A. Hughes, and Karen M. Kimmerite. I now call for hearing docket number E-2, sub 1300, which is the application of Duke Energy Progress, or DEP, for an adjustment of rates and charges applicable to electric utility service in North Carolina. As I'm required to do by the State Government Ethics Act, I remind members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any member of the Commission has a known conflict with respect to the matters coming before us in this proceeding. The record will reflect that no conflicts have been identified, so we will proceed. In late 2021, legislation authorizing the performance-based regulation of electric public utilities operating in North Carolina was enacted by the General Assembly and signed into law by the governor. This legislation, which has now been codified as Section 62-133.16 of the North Carolina General Statutes, establishes an alternative rate-making approach that, among other things, expands upon the traditional historic test year method of setting rates and authorizes the setting of rates based on a multi-year projection of costs. Section 62-133.16 requires that an application to use this alternative rate-making approach include a decoupling rate-making mechanism, one or more performance incentive mechanisms, and a multi-year rate plan, as well as an earnings sharing mechanism and proposed revenue requirements and base rates for each of the years that the multi-year plan would be in effect. Section 62-133.16 directed the Commission to adopt rules to implement the requirements of the statute, including a pre-application technical conference on proposed transmission and distribution expenditures. Accordingly, the Commission adopted Rule R1-17B, which establishes the procedures for the Commission's implementation of the statute. On June 8, 2022, in accordance with Rule R1-17B, DEP filed its request that the Commission initiate a technical conference regarding the projected transmission and distribution projects to be included in the company's impending application. In response to this request, the Commission opened this docket. On June 15, 2022, the Commission issued an order scheduling a technical conference to be held on July 25, 2022 for this purpose. The technical conference was held on July 25th as scheduled. On September 12th and 13th, 2022, DEP, the public staff, and SIG 2 caused to be filed in this docket an agreement and partial settlement regarding the methodology for allocating production and transmission demand-related costs. On October 6th, 2022, DEP filed its application to adjust its retail base rates, as well as a request for an accounting order, along with a direct testimony and exhibits of 22 witnesses supporting its application. In its application, DEP requests the authority to increase its rates and charges to produce additional overall North Carolina annual base revenues of approximately $623.5 million. DEP seeks approval from the Commission to implement for the first time performance-based regulation with a 3-year rate plan, as authorized by Section 62-133.16 of the General Statutes and Commission Rule R1-17B. DEP's request includes a general base rate increase as well as increases over each of the 3 years for a total increase in base revenues of approximately 18%. Broken down by year, DEP's requests an increase of 6.6% to general base revenues plus an additional 3.1% in rate year 1, 4.3% in rate year 2, and 4% in rate year 3. In addition, DEP has requested the approval of a residential decoupling mechanism, an earnings sharing mechanism, and performance incentive mechanisms. DEP proposes to offset the requested increase in part by a refund of $8.5 million of excess deferred income taxes resulting from the 2017 Federal Tax Cuts and Jobs Act and a reduction in North Carolina's state corporate tax rate. On October 31st, 2022, the Commission issued an order establishing the general rate case and suspending the proposed rates. On December 16th, 2022, the Commission issued an order scheduling the investigation and hearings and establishing intervention and testimony due dates as well as discovery guidelines. The order set the case for expert witness hearing beginning at 2 p.m. on Monday, May 1st, 2023, and continuing as necessary until its conclusion, and scheduled several public witness hearings as well. The order also required that DEP provide notice of its request to increase rates to customers by bill insert and by newspaper publication. On February 13th, 2023, DEP filed supplemental direct testimony for 15 of its witnesses. On March 17th, 2023, DEP filed second supplemental direct testimony and exhibits for 2 of its witnesses. In late February, March, and early April 2023, in accordance with procedural orders issued in this docket, the Commission held public witness hearings in Waynesville, Roxborough, Raleigh, Snow Hill, and Lumberton, and conducted one public witness hearing virtually for the purpose of receiving testimony from DEP's customers regarding the proposed rate increase. Formal parties to this proceeding are numerous. The public staff, which represents the using and consuming public, has been made a party to this case pursuant to North Carolina General Statute, Section 62-15. The Attorney General's Office has intervened in this case in accordance with North Carolina General Statute, Section 62-20. In addition to the public staff and the Attorney General's Office, the following parties have petitioned to and been allowed to intervene by order of the Commission: the Carolina Industrial Group for Fair Utility Rates 2, or SIGFR 2, Carolina Utility Customers Association, Inc., or CUCA, the North Carolina Justice Center, the North Carolina Housing Coalition, the Southern Alliance for Clean Energy, the North Carolina Sustainable Energy Association, Vote Solar, the Natural Resources Defense Council, the Sierra Club, the Commercial Group, the Kroger Company, Harris Teeter LLC, Fayetteville Public Works Commission, the Department of Defense, and all other federal executive agencies jointly, Haywood EMC, the Carolinas Clean Energy Business Association, and the North Carolina League of Municipalities. On March 27th, 2023, the public staff filed testimony and exhibits for 15 witnesses. In addition, on that same date, 10 other intervening parties filed testimony and exhibits on behalf of their witnesses. On April 14th, 2023, DEP filed rebuttal testimony and exhibits for 22 of its witnesses. On April 18th, 2023, DEP filed the third supplemental direct testimony and exhibits of 2 of its witnesses and the second supplemental testimony of 1 of its witnesses. On April 25th, 2023, DEP filed a notice of partial revenue requirement settlement agreement. Thereafter, on April 26th, DEP and the public staff jointly filed an agreement and stipulation of partial settlement relating primarily to matters associated with the revenue requirement. On April 17th, 2023, the public staff filed a transmission cost allocation agreement and stipulation of settlement. Also on that date, the Commission issued an order continuing the expert witness hearing until today, May 4th, 2023, to allow parties in the Commission to review the stipulations and supporting testimony. On April 28th, DEP filed settlement testimony and exhibits for 4 of its witnesses. On May 1st, DEP filed an agreement and stipulation of settlement on performance incentive mechanisms, tracking metrics, and decoupling mechanisms between DEP, SIGFR 2, and the public staff. Also on May 1st, DEP filed the agreement and stipulation of settlement between DEP and SIGFR 2 related to power quality. Also on May 1st, the public staff filed supplemental testimony for 2 of its witnesses, settlement testimony for 2 of its witnesses, and supplemental and settlement testimony for 2 of its witnesses. On May 2nd, SIGFR 2 filed testimony for its witness supporting the power quality settlement. On May 2nd, DEP filed the amended agreement and stipulation of partial settlement between DEP, the public staff, and SIGFR 2 related to performance incentive mechanisms, tracking metrics, and decoupling mechanism. Also on May 2nd, in support of the agreement and stipulation of settlement on performance incentive mechanisms that was filed on May the 1st, the public staff filed settlement testimony for 2 of its witnesses, and DEP filed settlement testimony for 2 of its witnesses. I think I've covered everything. All right, that brings us to today. I call upon counsel for the parties to announce their appearances, beginning with the applicant.
Thank you, Chair Mitchell. Commissioners, Jack Jirac, Duke Energy, on behalf of DEP. I'm joined this morning by Kendrick Fentress with Duke Energy and Karan Mehta with the law firm Trout & Pepper. We'll have a number of other attorneys handling various witnesses develop and make their introductions when they've previously provided notice of appearances.
Good morning, Mr. Jirac. Public staff.
Good morning, Chair, Commissioners. Robert Josie, along with Nadia Lohr, Ann Keyworth, Will Freeman, Zeke Creech, Tom Felling, and Lucy Edmondson, representing the public staff on behalf of the using and consuming public.
All right. Good morning, Mr. Josie, and to your colleagues on the public staff.
Morning. Gerald Moore on behalf of the Attorney General's Office, representing the state and its citizens.
Good morning, Mr. Moore. Go ahead.
Good morning. Craig Schauer on behalf of CUCA. With me over the course of the hearing, I'll be joined by Marcus Traven and Matt Tynan, who have filed notices of appearance.
Good morning, Mr. Schauer.
Good Good morning, Chair Mitchell and Commissioners. David Neal of the Southern Environmental Law Center, appearing today on behalf of the North Carolina Justice Center, North Carolina Housing Coalition, Southern Alliance for Clean Energy, Natural Resources Defense Council, and Vote Solar. We'll refer to as NCJC et al. From here on out, and my colleagues will introduce themselves as well.
Good morning, Commission. Menashe Magarir, Staff Attorney, appearing on behalf of NCJC et al.
Good morning. My name is Thomas Gooding. I'm an Associate Attorney with SCLC, and I'm also appearing on behalf of NCJC et al.
All right. Good morning, gentlemen.
Good morning, Chair Mitchell and Commissioners. Christina Kress with the law firm of Bailey and Dixon here this morning on behalf of Sigford 2 as well as Haywood EMC. I am joined by my colleague Douglas or DC Conant, also of the law firm Bailey and Dixon. In addition, Chris Edwards of the law firm Ward and Smith has entered a notice of appearance on behalf of Sigford 2. And in case I didn't already mention this, I am also here representing Haywood EMC. Thank you.
All right. Good morning, Ms. Kress.
James West, I'm the Chief Legal Officer of the Fayetteville Public Works Commission. Morning, Commissioners. I'm joined by Dustin Doty, our Senior Legal Counsel.
All right. Good morning, gentlemen.
Morning, Commissioners. Alan Jenkins for the Commercial Group.
Good morning, Mr. Jenkins.
Morning, Commissioners. I'm Kurt Bain, representing the Burger Company in Harris Teeter.
Good morning, Mr. Boehm.
Morning, Chair Mitchell, Commissioners. Ben Snowden, from Fox Rothschild, here on behalf of the North Carolina municipalities. I'm joined by my colleague Jack Taggart, also of Fox Rothschild. Also with us today, although not entering an appearance, is Jordan Kanzler, who is counsel for the in-house counsel for the municipalities.
Good morning, Mr. Snowden.
Morning, Chair Mitchell, Commissioners. John Burns here for Carolina's Clean Energy Business Association.
Good morning, Mr. Burns.
Chair Mitchell and Commissioners, I'm Justice Molofsky, Associate Attorney with the Sierra Club and Barry Bonvecchio of the Bob's Brian Grace Jr. Sierra Club fellow Reed Sigenheim.
All right. Good morning to you and your colleagues.
Morning, Taylor Jones, representing the North Carolina Sustainable Energy Association. A notice of appearance has also been filed by my colleague Ethan Blumenthal. He'll be representing NCSEA during the course of this hearing as well.
Good morning, Ms. Jones.
Good morning, Chairman Mitchell and Commissioners. My name is Kyle Smith, and I'm the representative for the United States Department of Defense and all other federal executive agencies.
Good morning, Mr. Smith. All right. Anyone else needing to make an appearance? All right. With that, we will take up preliminary matters.
Thank you, Chair Mitchell. Duke has a number of pending filed motions to excuse that I know the commission has in front of them and will be considering at the appropriate time. At this time, the company would like to move into the record a number of documents with your leave.
All right, please proceed.
Thank you. So at this time, Chair Mitchell, we'd ask that the company's transmission and distribution informational filing made on July 15th, 2022 be moved into the record.
Motion's allowed.
Thank you. We would also move that the company's PBR application and all supporting exhibits and E1s that were filed on October 6, 2022 be entered into the record and at the appropriate time.
All right. Hearing no objection, motion's allowed.
Thank you. Next, Chair Mitchell, we will move on to a number of settlement agreements that have been filed with the commission in this docket. And before I move those into the record, I would just briefly note that the company sincerely appreciates the engagement of public staff and all parties in this docket in reaching settlement on a wide range of issues. And we appreciate the constructive engagement we had from all parties in doing that. We think it's been a good process that has narrowed the issues in this case. And we, again, sincerely appreciate that. We'll start with the first agreement would be the agreement and stipulation of partial settlement with public staff, Duke Energy Carolinas, LLC, Sigford 2 and Sigford 3 filed on September 12th, 2022, and the amendment filed on September 13th, 2022. This is the cost of service settlement.
All right. Hearing no objection, your motion is allowed.
Next, two settlements will pair together. It's the agreement and stipulation of partial settlement with public staff filed on April 26, 2023, and an amended version of that agreement filed with the public staff and Sigford 2 on May 2nd, 2023. This is the partial revenue requirement settlement.
All right. Hearing no objection to that motion, it's allowed.
Thank you. Next, we would like to move into the record the transmission cost allocation agreement and stipulation of settlement with the public staff and Duke Energy's Carolinas LLC and Duke Energy Progress LLC, filed on April 27th, 2023.
All right, that motion is allowed.
Thank you. Next, we will move into the record the agreement and stipulation of settlement on performance incentive mechanisms, tracking metrics, and decoupling mechanism with the public staff and SIGFR 2, filed on May 1st, 2023.
All right, hearing no objection, that motion is allowed.
Next, we would like to move in the agreement and stipulation of settlement on power quality issues with SIGFR 2, filed on May 1st, 2023.
All right, that motion is allowed as well.
And finally, I would note for the benefit of the commission, we are in the process of filing an additional stipulation that we will move in the record after it's filed at the appropriate time.
Okay, thank you for that notice.
And that's all the preliminary matters we have at this time, Chair Mitchell.
Okay, at this time, let's address motions to excuse witnesses. I'll begin with the company, see if there are motions that need to be made at this time. None from Duke.
So our motions have all been previously filed with the
Okay.
commission, and we'll, if you'd like us to renew those motions, we can do so at this time.
No need to renew. We will address by order. All right, any parties that need to make a motion now that have not previously filed a motion with the commission?
SIGFR 2 has already filed a motion. Thank you.
Chair Mitchell, NCJC et al. Will just note that there's currently no cross listed for our witness, Mark Ellis. So if the commission doesn't have questions for him, we would move to have him waived as well.
All right, so questions for NCJC et al., Louise Ellis. All right, Mr. Neal, your motion to excuse your witness will be allowed.
Madam Chair, Alan Jenkins for the commercial group. No parties have crossed for Mr. Steve Chris. So we move his direct testimony and his summary of direct testimony.
All right, Mr. Jenkins, your motion will, we will excuse your witness. We will move. I'd ask that you hold your motion to move his testimony into the appropriate time. I will let you know when that is. All right.
Chair Mitchell, Ben Snowden for the North Carolina League of Municipalities. The league has introduced testimony from Mayor Bill Saffo and Mayor Terry Mann. No other parties have indicated cross-examination for them. The mayors are happy to appear and answer any questions from the commissioners, but if the commissioners do not have questions, we'd ask that they be excused.
Questions for the league's witnesses. All right. Mr. Snowden, your motion is allowed as to those witnesses being excused.
Okay, thank you.
All right, any other motions to excuse witnesses need to be made at this time? All right, with that, then we will proceed. Duke, case is with you. Please call your first witnesses.
Thank you, Chair Mitchell. At this time, Duke Energy would call the witnesses Kendall Bowman and Leslie Quick to the stand.
All right, good morning, Ms. Bowman and Ms. Quick. If you would, raise right hands, left hand on the Bible. You swear the testimony you're about to give should be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, Mr. Track.
Thank you.
I'm sorry, will you identify which one of you is which? Kendall Bowman. Yeah.
Thank you. Ms. Bowman, for the record, would you please state your name and business address?
Kendall Bowman, 410 South Wilmington Street, Raleigh, North Carolina, 27601.
And by whom are you employed and in what capacity?
Duke Energy, and I am Duke Energy's North Carolina State President.
Ms. Bowman, on December 20th, 2022, did you cause to be pre-filed in docket E-2 sub 1300 direct testimony consisting of 24 pages?
Yes.
And on April 28th, 2023, did you cause to be pre-filed in the same docket settlement supporting testimony consisting of 6 pages?
Yes.
Do you have any changes or corrections to your pre-filed direct or settlement supporting testimony?
I do not.
If I were to ask you the same questions today under oath, would your answers be the same as are set forth in that pre-filed testimony?
Yes, they would.
Chair Mitchell, at this time, I would ask that Ms. Bowman's pre-filed direct and settlement supporting testimony be entered into the record as if given orally here today.
All right. The direct testimony of witness Bowman filed on December 20th, 2022, consisting of 24 pages, will be copied into the record as if given orally from the stand. The settlement testimony filed by Ms. Bowman on April 28th, 2023, consisting of 6 pages, will be copied into the record as if given orally from the stand.
And Ms. Bowman, did you also cause to be pre-filed a summary of your direct testimony and settlement supporting testimony as well?
Yes, I did.
And Chair Mitchell would ask that the summaries also be entered into the record as if given orally today.
All right. The summaries of testimony filed by Ms. Bowman will be copied into the record as if given orally from the stand.
Thank you. Now, Ms. Quick, turning to you, would you please state your name and business address for the record?
Leslie Quick, 400 South Tryon, Charlotte, North Carolina.
Thank you. And by whom are you employed and in what capacity?
Duke Energy Corporation, and I'm the Vice President of Customer Technology, Advocacy, Regulatory, and Business Support.
Thank you. And on October 6, 2022, did you cause to be pre-filed in this docket direct testimony consisting of 49 pages and 1 exhibit?
Yes.
Okay. And do you have any change? Have you filed any changes or corrections to your pre-filed direct testimony?
Yes.
Okay. And with that correction, if I were to ask you the same questions today under oath, would your answers be the same as are set forth in your pre-filed direct testimony?
Yes.
Did you also cause to be filed in this docket a summary of your direct testimony?
Yes.
Okay. Chair Mitchell, with your permission, I would like at this time move in the direct testimony of Leslie Quick along with her exhibit and the summation of her testimony that was filed in this docket.
All right. The direct testimony filed by Ms. Quick on October 6, 2022, consisting of 49 pages and 1 exhibit. Well, strike the exhibit. As later corrected, will be copied into the record as if given orally from the stand. The exhibit will be marked for identification, as was when pre-filed, and we will take a motion to move the exhibit in at the appropriate time.
Thank you.
Summary will be copied into the record as if given orally from the stand as well.
Thank you, Chair Mitchell. At this time, the panel is now available for cross-examination.
All right. Ms. Kress, are you up first?
Unfortunately, yes,
Okay.
Chair Mitchell.
Proceed.
Thank you. Good morning, Ms. Bowman. Good morning, Ms. Quick. And for the court reporter's benefit, Christina Kress appearing on behalf of SIGFR 2 and asking some questions on behalf of SIGFR 2 this morning. I believe all of my questions are going to be directed to you, Ms. Quick, but feel free to jump in at any time, Ms. Bowman. Ms. Quick, you testify on page 4 of your direct testimony about the company's affordability ecosystem. Is that correct?
Yes.
And the company's affordability ecosystem is as described by you, multi-pronged approach to addressing both the short-term and long-term affordability challenges faced by the company's low-income residential customers. Is that right?
Yes.
And this includes working with low-income residential customers to connect them with agencies who administer financial assistance programs like the Low-Income Energy Assistance Program, or LIEP, and the Crisis Intervention Program, or CIP. Is that correct?
Yes.
And LIEP and CIP are both federally funded programs. Is that right?
Yes.
And the only customers eligible for LIEP and CIP funds are residential households that have at least one person residing in the household who meets the income eligibility criteria. Is that correct?
Subject to check. Yes.
And the individual income eligibility threshold for LIEP is based on income levels at or below 130% of federal poverty levels. Is that correct?
I believe it's 150%, but you could be correct with 130%.
Would you agree, subject to check?
Subject to check.
That it is
Yes.
130% of federal poverty levels? Okay. And then for CIP, which is maybe what you were thinking of, the eligibility is based on income level thresholds of at or below 150% of federal poverty levels. Is that correct?
Yes.
Okay. And the company in this case is proposing individual income eligibility thresholds to be based on income levels at or below 200% of the federal poverty levels. Is that right?
Can you restate that?
The company is proposing in this case for individual income eligibility thresholds to be based on income levels at or below 200% of the federal poverty levels. Is that right?
I believe that question would be better answered by Witness Harris. I believe you're referring to the Customer Assistance Program, the CAP program that we're putting forward in this case.
And so Witness Quick, you do testify, do you not, in your direct testimony about the proposed customer assistance program?
Yes.
And in fact, correct me if I'm wrong, but you referenced the 200% income eligibility threshold in your direct testimony. Is that right?
I do reference the 200% in my direct testimony, yes, as it relates to how we classify low-income customers.
And would the company's classification of low-income customers at that 200% threshold also be the criteria used in the customer assistance program?
So the criteria that'll be used in the customer assistance program will be eligibility, customers who are eligible for LIHEAP, SIP funds that will be deemed by our state agency, North Carolina DHHS.
And so happy to save the rest of this line for Witness Harris if that would be more appropriate, but I do have a couple more questions. In addition to LIHEAP and SIP, the company also has a Share the Light fund, which you testify about, that assists residential customers who are struggling to pay their bills. Is that right?
Yes.
And the Duke Energy Foundation matches every dollar donated up to $375,000 according to your testimony. Is that correct?
Yes.
Are you aware that as of this morning, the DEP North Carolina website indicates that the Duke Energy Foundation will match every dollar donated up to $500,000?
I'm not aware of that.
Do you know when the change was made to reduce that matching level from 500,000 to 375,000 and why it was made?
I do not.
So in addition to, we've talked about this morning, LIHEAP, SIP, and Share the Light, there are still more programs benefiting low-income residential customers. Is that right?
Yes.
And some of those include, per your testimony, the Helping Home Fund and the Neighborhood Energy Saver Program. Is that correct?
Yes. And I would also just add that we were able to, there were a lot of assistant agencies and channels. We were able to get our customers over the 2021 timeframe over 50 million in assistance. So yes, that's comprised of a lot of agencies that we partner with.
And you acknowledged in your testimony, do you not, that the company has specifically focused in this rate case on addressing affordability challenges faced by low-income residential customers? Is that right?
Yes. And as part of the rebuttal panel, we have an affordability panel that will talk more about affordability in general and the programs we offer.
Thank you for that. And I believe you also testify that, quote, DEP is committed to addressing energy affordability challenges by designing and providing products and services to these low-income residential customers as part of the affordability ecosystem. Is that right?
Yes. And most recently, we got our income qualified energy efficiency and weatherization program approved.
Thank you. So that is still another program benefiting low-income customers that we haven't even discussed yet this morning.
Yes.
And it's fair to say, is it not, that some of the recommendations stemming from the Low Income Affordability Collaborative, or LIAC, were not consensus recommendations.
I think that question would be better addressed by witness Barnes.
On the rebuttal panel for,
Yeah, the affordability panel.
I'm happy to redirect that to Ms. Barnes. Okay, so moving on then. You've previously testified that LIEP and SIP are federally funded programs. I want to ask about the customer assistance program being proposed by the company in this rate case. Would that too be a federally funded program?
No, but I think that also will be better addressed by the affordability panel and witness Harris in particular.
And so if we have questions about the company's proposed CAP program in the context of House Bill 951, would that also be better directed to witness Harris?
Yes.
Okay. Then I am happy to save the rest of this line for witness Harris. Chair Mitchell, I would note that it is my understanding that a stipulation that is relevant to some of these topics is potentially going to be filed later today. And having not had a chance to see that stipulation yet, SIGFR 2 may have some additional questions for this panel as soon as it has had a chance to review the terms of that stipulation. And so SIGFR 2 would like to reserve its right to ask additional questions on cross once it has had a chance to review that stipulation.
Did you want to be heard, Mr. Dirac?
If I may.
Go ahead.
So the stipulation, we will be glad to file, we will be filing supporting supplemental testimony to support that particular stipulation. And so I would suggest that questions regarding that stipulation be directed at that, so that the witnesses that submit that supporting settlement testimony rather than this panel. In addition to the fact that all of the issues addressed by that stipulation are still probably better handled by the low-income panel that is still to be presented at a later point in this proceedings. I don't think that this panel needs to be reserved at this time.
Chair Mitchell, she testified, Ms. Quick testifies fairly extensively about all that the company is doing and currently and as proposed in this rate case related to low-income assistance programs. And so I do think that there is a chance that additional questions might be appropriately directed for this panel.
Sorry.
Go ahead, Ms. Kress.
And so I would disagree respectfully with Mr. Dirac's assessment.
Mr.
If I
Dirac.
respond one more time, Ms. Quick, to be clear, Ms. Quick is on the low-income affordability panel. So SIGFR will have ample opportunity to ask Ms. Quick the exact questions she wants to ask in the context of the affordability panel.
All right. In recognition of the fact that counsel for the company is indicating that testimony supporting the stipulation will be filed at the time the stipulation is filed, I'll give you an opportunity to review all of the filings and resume your cross-examination of the panel, which includes Ms. Quick at that time. But a different panel than the panel we have up now.
Understood. Thank you. As long as we can continue to ask questions about Ms. Quick's direct, I think that addresses our issue.
So my understanding is that your cross-examination on Ms. Quick's direct is now complete. Is that not the case?
Okay, understood.
Okay.
Now I am clear.
Okay.
Thank you.
All right. Okay. Is your cross?
It is.
Okay.
It is
Thank
done.
you.
Thank you.
Thank you, Ms. Kress. All right. Who's up next?
Good morning, Craig Shower on behalf of CUCA. Ms. Bowman, my questions will be directed towards you. My apologies, Ms. Quick. Ms. Bowman, I'll start off by saying congratulations on your new position as president. At the beginning of your testimony, you identify some of your new responsibilities as president, don't you?
Yes, I do.
Right. And as president, you are responsible for regulatory affairs, regulatory filings, and community relations. Am I correct?
Amongst other things.
And one of your additional responsibilities is regarding the financial performance of the company's electric utilities, correct?
That's correct, for Duke Energy Carolinas and Duke Energy Progress.
Your responsibility for the company's financial performance, that includes owing a fiduciary duty to shareholders to maximize the company's earnings.
That is correct.
You testified on page 12 of your testimony, and I'll just quote it for you, that House Bill 951 recognizes that achievement of the targeted CO2 reductions requires the modernization of the rate-making construct. Do you see that on page 12, line 5 through 7?
I see that.
Right. And when you say modernization of the rate-making construct, as described as referenced on page 12, you are referring to performance-based regulation. Am I right?
Yes, and all that ensues in performance-based rate regulation, the multi-year rate plan, earnings sharing mechanism, PIMS, decoupling.
Is it your testimony that the General Assembly, in passing House Bill 951, stated that Duke must have performance-based regulation to achieve the carbon plan?
I believe House Bill 951 for PBR allows the utility to make a filing to this commission to determine if the PBR is in the public interest. At Duke Energy, we believe we need to have a PBR in place for us to move into the clean energy transition to keep reliable, cleaner energy for our customers.
Right. But to be clear, the General Assembly didn't make a finding that said Duke must have performance-based regulation in order to achieve the carbon plan.
I believe the General Assembly recognized that having a modern regulatory construct would be beneficial in achieving the policy goals set forth in 951 of transitioning to a cleaner energy future.
But nowhere in House Bill 951 did the General Assembly say that performance-based regulation is required to achieve the carbon plan. Am I correct?
I believe I answered your question previously in what I believe House Bill 951 says, that the utilities can make a filing for a PBR application.
Section 62-133-16, that is the codification of performance-based regulation. Am I right?
Subject to check, yes.
If I could, I'd like to hand out my binder, which I failed to do before asking questions, and reference one of the exhibits. Apologies, 1 second.
All right, you may.
Chair Mitchell, I'd like to introduce an exhibit, which is CUCA Potential Cross Exhibit 1, which Ms. Bowman is the first tab in the binder before you that I just handed you. And right, and I would propose to mark this CUCA Cross Bowman and Quick Direct Exhibit 1.
All right, Mr. Shower, I see that this is the an excerpt from chapter 62, specifically 62-133.16. Commission can take judicial notice of this statute, just so we don't have excess material in the record.
Sure, this will be referencing it. It was just for convenience.
All right, so witness has it in front of her, but we will take judicial notice of the statute.
Thank you. Ms. Bowman, if you look at subsection B, which I believe is on the first page of the statute print I gave you, it says merely that the commission is authorized to approve performance-based regulation, correct?
Yes, that's correct.
So the law empowers the commission to adopt performance-based regulation. It does not say that the commission must adopt performance-based regulation.
Yes, and I mentioned that earlier.
And if you turn to what would be page 4 of the printout, subsection D, D1 goes on to say that the commission cannot approve performance-based regulation unless it finds that DEP's application is in the public interest. Am I correct?
Chair Mitchell, may I? Just in the interest of efficiency, council is reading the statute. We stipulate the statute says what it says, and he's asking Ms. Bowman to confirm that the statute says what it says. We would ask that questions refrain from seeking legal opinion from a non-attorney at this time.
I believe Ms. Bowman has a law degree. Am I correct?
She's not practicing as an attorney currently. She's not appearing before this commission as an attorney either.
Sure. Chair Mitchell, I'm just laying groundwork for.
All right, let's do this. I'm going to overrule your objection, Mr. Dirac. I'm going to accept that you're laying this question for groundwork. So let's move on to the next question, Mr. Shower.
So regarding the public interest, page 12 of your testimony says that DEP's PBR application is in the public interest because it, quote, better positions the company to 1, meet the state's carbon reduction goals, 2, meet customer expectations, and 3, keep rates affordable. Do you see that in your testimony?
What lines?
Lines 15 through 18.
On page 12?
I believe so.
It says this transition is occurring across the electric utility industry and it's also driving significant investment in the grid to improve reliability and resiliency and to support growth in distributed generation. In light of this transition, House Bill 951 introduces modern rate-making practices that will better position the company to meet the state's policy goals and customer expectations while keeping rates affordable.
Right. And so to summarize that testimony, it better positions the company to meet the state's carbon reduction goals, which is one of the policy goals, 2, to meet customer expectations, and it also keeps rates affordable, correct?
And also ensures that we have a reliable grid. That's one of the founding principles in 951.
In terms of achieving the state's carbon reduction goals, is it Duke's position that unless the commission adopts performance-based regulation, it would be impossible for the company to achieve the state's carbon reduction goals?
We believe it's in the public interest to have a modern regulatory construct such as PBR to help us achieve the carbon reduction goals in the most efficient, affordable, and reliable manner.
But could DEP achieve those carbon goals without performance-based regulation?
I believe it's possible, but I don't believe it would be as efficient or affordable or as reliable, and would probably take longer.
The second benefit that you discuss on page 12 is that the PBR application will allow Duke to, quote, meet customer expectations. Turning to page 14 of your testimony, line 20 through 22, I believe you elaborate on customer expectations. And I believe you explain, starting on line 20 of page 14, that Duke needs to do more to improve the energy infrastructure required to meet the needs of customers. In other words, that's an expectation customers have. Correct?
That is correct. A lot of our customers are expecting us to transition to a cleaner energy future. You have more distributed energy resources out there. We're also deploying smart grid technology, self-healing technology to be able to restore power quicker. Also offering customers more programs when you think of our smart meters. So there's a lot of investments that need to be made into the grid in order to accommodate the growing needs and demands of our customers and ensuring that we have reliability. We all went through a pandemic where we all had to learn to work from home. Kids started online classes, and the importance of having electricity was never more profound in that time. And so we need to make these investments to keep up with our customers' growing expectations.
And one of the investments you mentioned was an investment in a smarter grid, correct?
And that entails multiple different investments.
Right. Your testimony on at the bottom of 14, at the top of 15, also mentions improvements such as hardening and resiliency, targeted undergrounding, and self-optimizing grid programs. Do you see that?
I do.
Right. In the past years, Duke made investments in these grid improvements without performance-based regulation, didn't it?
In the last rate case, we were granted a grid deferral, which helped us be able to achieve some of these investments. Now that we have a PBR and a multi-year rate plan, that will take the place of that deferral and will give us the ability to make these investments and get recovery in a real-time timeframe. The nature of these types of investments is not like the traditional large power plant. These are made project by project, and with this, Bateman can go into more detail on this topic, but we had that deferral in place, and now with the multi-year rate plan, this will give us, I believe, a better regulatory mechanism that benefits both the company and our customers.
Right, but to be clear, Duke was able to make those investments in the past without performance-based regulation.
Well, we're talking about different types of investments going forward now. We had that deferral in place, and we're finishing those investments. Now we're projecting out new investments. If you look out for the multi-year rate plan, what we've proposed in years 2 and 3 in this case.
Sure, but different types of grid improvements. Correct. In other words, Duke has been able to make grid improvements in the past without performance-based regulation, and now it's seeking to make
We're
more.
looking to make not just grid improvements
So
going
I could-
forward. We're looking to make investments in things such as solar and storage and other technologies. It's not just the grid that we're looking at through the future in the multi-year rate plan.
Sure. If you could just please allow me to finish my questions. But what we're talking about here is customer expectations, and one of the things we've discussed are customer expectations include improvements to the grid. And am I correct that Duke has made improvements to the grid such as hardening and resiliency, targeting undergrounding, and self-optimizing grid programs in the absence of a performance-based rate program?
Yes.
Thank you. So is it Duke's position that unless the commission adopts performance-based regulation, it would be impossible for Duke to invest in such grid improvements in the future?
I would not say impossible. I think it will be extremely difficult. And again, as I mentioned before, I think having alternative rate making is something that is beneficial to the customers as well. I think the General Assembly of North Carolina saw that when they allowed for PBR application in House Bill 951. There are over 30 other states in the country that have alternative rate making structures similar to PBR. I think 951 brought North Carolina in line with a large majority of the rest of the country.
On page 15 of your testimony, lines 17 and 18, you say that customers desire an improved experience with more streamlined options and versatility.
Chair Mitchell, may I just briefly, can you, are the page numbers that you're referencing are not matching up to the page numbers on our hard copy? I want to make sure that witness Bowman is able to locate the reference pages.
So I'm looking at Ms. Bowman's direct testimony, page 15, lines 17 and 18, where it says our customers desire an improved experience with more streamlined options and versatility.
Is that matching your testimony, Ms. Bowman?
It is.
Okay.
So you go on page 16 to then list smart meters and customer connect as examples of technology enhancements for customers. Do you recall that from your
Yes.
testimony? Again, is it Duke's position that unless the commission adopts performance-based regulation, that it would be impossible for Duke to invest in such technology enhancements?
No, we were making those investments
Prior to.
prior
the
to.
application.
But as I said before, we believe it is important for us to be able to institute PBR. We believe it is in the best interest of customers going forward.
Then the third, I'm sorry, in your testimony regarding the public interest, the third reason you discussed for the PBR application being in the public interest is that it will help keep rates affordable. Am I correct?
Where are you reading from?
I'm going back to page 12, lines 15 through 18. where it says the PBR will better position the company to meet the state's carbon reduction goals.
While keeping rates affordable, yes.
Thank you. So after the partial revenue requirement settlement with the public staff, Ms. LaWanda Jiggets of Duke submitted a settlement exhibit on behalf of Duke that shows Duke is seeking to collect an additional $594 million from ratepayers over 3 years. Is that correct? That amount?
Subject to check. I don't have that exhibit in front of me.
An additional $594 million is an increase in revenues of about 14% over 3 years. Does that sound correct?
I would
Subject-
prefer that you ask this line of questioning to Ms. Jiggets.
Well, subject to check. Is that a 14% increase in revenues?
I haven't looked at the exhibit, so subject to check.
Looking again at the statute, subsection D1 requires the commission, when reviewing a PBR application, to consider whether the application will, quote, result in sudden substantial rate increases or rate shock to customers. Are you familiar with that requirement?
I am.
Is it Duke's position that a total increase of 14% over 3 years is not rate shock for Duke's customers?
I think you have to take it year by year, and you have to look at the breakdown in different customer classes. So we do not believe it is rate shock when you take it year over year.
So spreading it out over 3 years reduces the shock?
And it is spread out over 3 years.
I'm sorry, but so spreading it out over 3 years eliminates the potential shock of the increase? Is that your testimony?
My testimony is that we do not believe it is rate shock, and it spreads it out over 3 years.
Why is it not rate shock? Because it's spread out over 3 years?
It's both.
I'm sorry, so
A 14% increase and you're spreading it out over 3 years does not constitute rate shock. And if you look at the statute, there are also enhanced guardrails and customer protections that the General Assembly put in place. For the multi-year rate plan, there is a cap on no more than a 4% rate increase for years 2 and 3 for customers. So the General Assembly, when they enacted this, they made sure to put in guardrails. There's also an earnings sharing mechanism that the utilities have never had before, the electric utilities have never had before. So anything that is 50 basis points above our allowed return gets refunded to customers. So that is another guardrail that doesn't exist in the current paradigm today. The General Assembly was very thoughtful in looking at customer protections when they passed this legislation.
well, in addition to the 4% guardrail, the General Assembly also instructed the commission to consider whether or not the PBR application resulted in rate shock, which would imply that an increase less than 4% a year could result in rate shock, correct?
I believe we just went through this discussion. The statute has the rate shock criteria in there, which this commission is going to consider.
Am I correct that DEP's sister company, DEC, applied for a fuel rider adjustment that will result in a total bill increase of about 18%?
Chair Mitchell? Thank you. I would object to a line of questioning on a docket it's a separate docket with a separate utility that's not in this proceeding.
Laying groundwork for questions relevant to the commission's review of the PBR application.
Repeat the question, please.
All right. Am I correct that DEP's sister company, DEC, applied for a fuel rider adjustment that will result in a total bill increase of about 18%?
All right, I'll let the witness answer the question, subject to check, and then let's move on.
Yes.
Yes, there is a pending filing in front of this commission for DEC's fuel.
Assuming that, well, that was, I'm sorry, for DEC's fuel? Did you say DEP or DEC's?
DEC, Duke Energy Carolinas.
So assuming DEP will seek a similar bill increase this year for fuel costs, if you add 18% for fuel and 14% for the multi-year rate plan, you get a total increase of 32% in 3 years, correct?
So you have to take into account that fuel is not constant. Fuel fluctuates, and we have an annual filing every year for fuel. And a lot of the fuel component is based upon the previous year. So it is what the utility spent the previous year and then a projection going forward, looking at that. And those rates constantly change. So it is not a constant. Also, we don't know ultimately what that rate increase would be. We recognize that it's never a good time for rates to increase for our customers. It's difficult. We recognize that. We're implementing ways to try to reduce costs. For example, the customer programs that Ms. Quick just talked about for our vulnerable customers. But we're also looking at all of our customers. We're looking at taking advantage of the IIJA, the Infrastructure Investment Jobs Act that the federal government passed, seeking every dollar we can to help reduce costs. We also plan to really utilize the Investment Reduction Act, the IRA, the tax credits for our customers. We're also continually trying to optimize our O&M to reduce costs for customers. We're proposing innovative rate designs, EEDSM programs to really incent customers to use less energy. So we're cognizant of rate increases. There's never a good time for a rate increase, but we're making investments for the reliability and operations of our grid. We have to provide electricity 24 hours a day. It's our statutory obligation, and we need to continue to make those investments, and we need to get cost recovery to ensure that we can maintain a financially viable utility.
So is it your position that a 32% increase over 3 years in a citizen's utility bill is not rate shock?
I do not believe you have the facts correct. I mean, you were conflating a DEC fuel case. We don't know the outcome of that. We don't know the outcome of this. You're compiling numbers together, and I don't believe it's an accurate comparison, and I can't give you an opinion on that.
Well, in an absolute manner, taking out all the caveats you put around it, would a 32% increase
Chair Mitchell,
in
may
a citizen's
I-
utility bill over 3 years be rate shock?
Chair Mitchell, the attorney has asked this question now probably 4 or 5 times, whether witness Bateman agrees that the increases before the commission are rate shock. She's answered it repeatedly. I would object to asking this question yet again.
I've asked this question twice, and neither time has she answered it.
All right. Well, let's do this. Ms. Bowman, answer its question, and then let's move on and answer it. It's a hypothetical question, so the commission will treat it as such and give the evidence it elicits the weight that it's due.
So hypothetically, a 32% increase in 1 year would be a large increase. But what is before this commission in this docket is a PBR application, and adding the fuel component onto that, the commission is to consider public interest in this docket, not other dockets.
So your testimony is that the commission should consider the PBR application in a vacuum, not considering other rate increases that consumers are facing.
They should consider the public interest of this PBR application.
Right. In the context of other rate increases that consumers could be facing.
That is the commission's prerogative.
On page 16 of your testimony, on line 11, you start to review certain rate mitigation efforts that Duke has taken to help customers absorb the rate increase. Do you recall that testimony?
Are you referring to the customer affordability section?
Yes. These rate mitigation efforts include, among other things, 1, not increasing the basic customer charge, 2, reductions in executive compensation. A third example is eliminating credit card fees for certain customers. And then the fourth thing that I noted was the customer assistance program for low-income customers. Am I correct that those are examples of rate mitigation efforts?
Yes, those are examples that I listed in my testimony.
And the customer assistance program, according to page 18 of your testimony, includes services such as a monthly bill credit, and possible energy efficiency enhancements. Am I right?
Yes, it's a bill assistance proposal and with a flat monthly bill credit. And there will be referrals for income qualified weatherization and EE programs.
The customer assistance program is for residential customers only, right?
That is correct.
What rate mitigation efforts is Duke proposing that will help industrial customers?
I believe that we have in place equal percentage for fuel. We also offer special time of use pricing rate schedules for our large industrial customers. We also have in place some economic development type of tariffs and riders for our large industrial customers as well. And as I mentioned earlier, we care about all of our customers, and we are trying to reduce cost and ways by applying for IIJA, IRA, looking at O&M savings where possible.
Now, the equal percentage for fuel, that doesn't allow an industrial customer to somehow receive a credit or a discount on their bill that would reduce their rates, correct? It's just a method of allocating costs.
For the fuel component, and I'm not the expert on this, so.
Right, but you cited it as a rate mitigation effort.
Yes.
How does that mitigate rates for industrial customers?
I believe it helps reduce some of their fuel.
And then the time of use, you're referencing the fact that there are certain periods when you can have a reduced rate if you avoid peak periods of demand. You're talking about that basic rate structure, correct?
Yes.
Right. Now, the time of use rate design is only helpful if an industrial customer has the operational flexibility to shift their operations to take advantage of those periods, correct?
That is correct.
And so if a company didn't have that operational flexibility, the time of use rates would not result in any rate relief for those customers. Am I right?
I think our industrial rates are very competitive in the nation. We are still below the national average. And I believe even with these rate increases projected in this case, we'll still be below the national average. We have great economic development here in North Carolina. I believe we still have very competitive energy prices. I believe last year was a banner year for the state of North Carolina in attracting economic development. I don't know if I remember the statistics off the top of my head, but I think it's looking like we could recruit over 17,000 jobs and about $13 billion in investment in the state of North Carolina. So I believe that we're continuing to focus on affordable rates for all of our customers. And I think if you look at the success of the state of North Carolina from an economic perspective, I think it will show that.
Right, but focusing on the time of use rates, which you referenced earlier, that only provides rate relief to an industrial customer if they have the flexibility to start and stop production around peak periods, correct?
Again, I'm not the expert on the time of use rates. We have rate design witnesses, if you would like to ask that question to them.
And then the third thing you mentioned was the economic development rider. Now, that only applies to new load or expansions for an industrial customer. It doesn't apply to existing load, correct?
I would need to look at the parameters. Again, I'm not the expert on those riders.
Did you review the pre-filed testimony of Charles Heilig, the president of Parkdale Mills?
I reviewed it, yes.
Parkdale, if you recall from his testimony, is one of the largest textile manufacturers in the world. Am I correct?
Subject to check.
Do you recall that he said that they currently have 8 manufacturing plants in North Carolina?
Subject to check.
And do you recall that he testified that energy costs are one of Parkdale's largest contributors to operating costs?
Subject to check.
And he said that labor and material costs, which are other components of operating costs, are constant across jurisdictions, whereas energy costs vary by jurisdiction. Do you recall that testimony?
Subject to check.
So, and therefore, he said that energy costs are a determining factor in locating its plants. Do you remember that important statement of his?
Subject to check.
Do you remember that he said that since 2016, quote, increasing utility costs were a, quote, contributing factor to the closure of 6 textile plants in North Carolina?
Subject to check.
Do you recall that he cautions that its plant in South Carolina, in Sanford, South Carolina, in other words, Parkdale's Sanford, South Carolina plant, I'm sorry, Sanford, apologies. Mr. Healy cautions in his testimony that its plant in Sanford, North Carolina is at risk of closure if DEP's rates increase. Do you recall that testimony?
Subject to check.
Subject to check, do you recall that the Sanford plant employs 150 people?
Subject to check.
If 150 employees lose their entire income because the Sanford plant is closed, Duke's low-income assistance programs won't help those citizens put food on the table, will they?
I am not sure I understand your question.
Well, let me put it into context. If you want to look at section 62-133-16 D1, it says that the commission, when reviewing a PBR application, is required to consider whether the PBR application, quote, assures that no customer or class of customers is unreasonably harmed. Would you consider unemployment a harm?
Chair Mitchell, man,
Go ahead.
I would object. There's been no foundation laid for this question to establish that this proceeding in front of the commission or the rate increases sought are the cause of the hypothetical unemployment situation or actual unemployment situations being faced by a particular customer. So I would just object that there's been an insufficient foundation for this question.
Okay, I'm gonna sustain the objection. Mr. Shower, restate your question, or just get to the point. Ask her getting to the point without walking through hypotheticals. Just ask the question in a different way.
Ms. Bowman, in your opinion, would the closure of a manufacturing plant, such as Parkdale's Sanford plant, be a reasonable harm that is acceptable under section 62-133-16?
Could you ask the question again?
Sure, and just to give you context again, section 62-133.16 D1A says that the PBR application, quote, assures that no customer or class of customers is unreasonably harmed. In your opinion, would the closure of a manufacturing plant, such as Parkdale's Sanford plant, as identified in Mr. Healy's testimony, would that be a reasonable harm that is acceptable under section 62-133-16?
I think under the statute and any closure of a plant is hard. It's hard for the community. It's hard for the employees. It's difficult. But if you look at the statute, I think it is having this commission look at the totality of the public interest across the footprint for Duke Energy progress. And it comes with pros and cons. So you'd have to look at it in totality.
So in other words, even though the closure could be hard, it might be acceptable under the statutory construct provided by the General Assembly?
Looking broadly, correct.
No further questions.
All right, Sierra Club.
Good morning, Justin Simolowski on behalf of Sierra Club. Chair Mitchell, we are waiving cross of the panel, and I would just like to know, per the stipulation that's going to be filed later this morning, there are several other witnesses we've reserved time to cross that we will also be waiving. Given this is the first one, at the appropriate time, once the stipulation is on file, we will notify the appropriate peoples so that is reflected in the witness list and this does not happen again.
Okay, thank you very much. All right, public staff, you're up.
Thank you. Morning, Ms. Bowman, Ms. Quick. I'm Robert Josie with Public Staff. Just have a few questions for you. Ms. Bowman, you stated earlier that there are many other states that have alternative rate-making mechanisms similar to PBRs. You said similar and not identical, correct?
That's correct.
Yeah. And are you including riders when you discuss that?
Yes.
And specifically, what are these alternative rate-making mechanisms that you're referring to in other states? Do you have any examples?
Well, there's a whole host, and Witness Bateman can probably give way more examples than I can. If for example, in Indiana, we have something called a T-DISC rider, where it's a rider where you can get real-time recovery of transmission and distribution expenses. I think in Florida, we have multi-year rate plans. A lot of other states have future test years, not historic test years, where you're projecting out in the future. So it's a myriad of all different types of alternative regulatory constructs out there.
All right, thank you. And you also mentioned as a rate mitigation measure the equal percentage fuel factor.
Yes, for industrial customers.
Yes, and then that is for industrial customers. So if you're mitigating, would you agree that if you're mitigating industrial customer bill impacts, that would fall on other rate classes?
Yes, it's a give and a take.
Yes, all right. Thank you. And as you were speaking to the bill impacts of the multi-year rate plan and the PBR earlier with Mr. Shower, it's true, isn't it true that Duke or DEP also has a lot of capital spend planned outside the multi-year rate plan for the next 3 years as well?
A lot of capital spend outside of could you ask your question again?
Is the multi-year rate plan the only capital spend that Duke Energy Progress is planning for in the next 3 years?
No, there will be others outside.
Okay, and that will also be included in rates at some point, correct?
In the future.
Yeah, all right. And as to rate shock, you mentioned that the commission should only be looking at this particular increase in this docket when trying to determine rate shock.
I believe for the PBR application, if you're looking at the context of the statute based on the previous line of questioning.
But when we talk about bill impact, we're talking about everything associated with a bill, correct?
If you're looking at the total bill impact.
And
yes.
that's what rate shock you would look at when you're talking about rate shock, is the total bill impact of everything that's included in the bill.
I could see that perspective.
Thank you. No further questions.
All right, redirect.
Just a few, if I may. Just one quick redirect from Ms. Quick. Ms. Quick, on your testimony on page, if you turn your testimony on page 11, bottom of page 11, line 22. This is in reference to questions from counsel for SIGFA regarding contributions, Duke Energy employee contributions to Share the Light Fund. Do you see that testimony?
Yes.
Can you read starting there on line 22 on page 11 and continuing on to page 12? Duke Energy employees, do you see that?
Duke Energy employs customers and Duke Energy employees, customers, and shareholders contribute to the Share the Light Fund, which is matched up to $375,000 annually from the Duke Energy Foundation.
And so that testimony is still accurate, correct?
Yes.
Okay, and you're not aware of the websites being mentioned. This testimony is still accurate, correct?
Yes.
Okay. Ms. Bowman, turning to you, just a few questions in as follow-up to questions asked by counsel for KUKA. Stepping back a moment, your testimony talks about 4 key drivers of this case. Do you recall that?
Yes.
And the first driver is a balanced transition to a cleaner energy. Call that?
Yes.
Next is operational excellence and reliability. Remember
Yes.
that? Next is enhancing the customer experience.
Yes.
Correct. Next is customer affordability.
Correct.
Ms. Bowman, is it your testimony that all of those drivers have to be balanced? That all of those have weight to be given as the company thinks about its investments and its actions in this case?
Yes.
And would you agree that customer affordability, as noted here, is one of the primary considerations the company has taken as it's developed this application?
It
correct?
is.
But is it also the case that investments are needed to ensure a reliable grid and deliver clean energy to customers, correct?
They absolutely are.
Okay. And so all of those factors must be balanced as the company thinks about its application, as the commission ultimately considers its application.
Yes.
And would you agree the company certainly sympathizes with the pressures that particular customers, whether they're residential customers or industrial customers or manufacturing customers, experience when it comes to electricity prices?
Absolutely.
Does the company engage with with all customers throughout its business to seek to better understand those challenges of individual customers?
We do. We have large account management team to work specifically with our large industrial customers. Under Leslie Quick, we have, customer service agents to help those customers that are struggling to develop financial plans. We actually developed a small business organization to help work with our customers. So we absolutely care and try to work with our customers.
Okay. And in that day-to-day engagement with the company's customers, does the company seek to identify solutions to assist its customers, be they residential customers or like complex industrial and manufacturing customers?
Yes, we do.
And through the extensive rate design workshop that the company conducted over the past year, did the company seek to engage industrial and commercial customers to better design rates to facilitate their operations?
Yes, we did. And I believe witness Bird will address some of those.
And as the company has engaged with the commercial and industrial customers across all phases of business, has it also heard from those customers that they desire reliability in their service?
Yes, reliability is always, and power quality are at the top of the list.
And does it take investment to provide reliable service to industrial and commercial customers?
Yes, every day we have to make investments for our operations to serve reliably.
And you testified just a minute ago about the remarkable economic development of the state. Do you believe that both the reliability and the low cost of Duke's energy services are a significant part of the economic development occurring in the state?
I do believe it's a significant part.
And as the company thinks about the service offers, how has the company sought to manage its O&M expenses in order to keep the rates as low as possible for businesses and residential customers of the state?
But we are always looking for efficiencies and ways to optimize the way we do our work, reduce unnecessary work where needed, streamlining efforts, digitizing things rather than hiring employees. We've invested a lot in drone technology, so we don't have to have employees actually manually inspecting lines. So we are always looking at ways to optimize and reduce and drive efficiencies out of our business.
And as we think about this case, a big part of this case is the company's presentation of historic capital investments that have been made for the benefit of customers, correct?
That's correct. That's the first part.
And the next piece is the projected capital investments that the company is putting forth in this MYRP for consideration by the commission.
That is correct.
And in all cases, in this case, the company has been required to demonstrate the prudence and the need for all of those investments, correct?
That is correct.
So is it your testimony that that the the rates that have been proposed in this case are reasonable in part because they're driven by a set of investments that the company believes are prudent, and necessary to provide reliable service to customers.
That is correct.
And taking all that into account as you look at this application, do you continue to believe that this application, the company's PBR application, is in the public interest and should be approved by this commission?
Yes, I do.
Thank you. I have no further questions at this time.
All right, we will move to questions from the commissioners. Commissioner Brown-Bland, questions?
Just a general kind of question. Is there anything unusual that you see, and I guess this is primarily to Ms. Baumann, about the pace of the increase in the cost of doing business, the infrastructure investments over a fairly recent span of time, say the last 20 to 25 years? Is there anything unusual about this pace in the increase of cost of doing business?
Well, I would certainly say that in light of the pandemic, supply chain constraints, labor cost increases, I mean, we're seeing costs go up. I think one of the great things about the Investment Reduction Act is we can take a lot of those tax incentives to help reduce those inflationary costs. I think we see a lot of, cost increases when you're trying to construct large infrastructure projects, and delays in permitting and those things that are driving costs up. We're in a clean energy transition. We're not the only ones in the country trying to go to this. So we're out there competing for capital. We're competing for labor. We're competing for materials. So we need to continue to be competitive, and we need to continue to be financially healthy so that we can get out and compete with the rest of the utilities to help us.
And even before clean was high up on the list as the driving force, there was a lot of discussion in the industry around just aging infrastructure as well. So we were already in a place of having to replace or renew or add addition, that kind of thing from growth, right? Was that increase at a faster pace or causing a faster pace of increase in the cost, not the bill, but just the cost that the company experiences in providing service?
I think you add on top of transforming to a clean energy future along with an aging infrastructure. We're looking at replacing one of the largest coal fleets in the nation, and that is a huge undertaking. In addition to upgrading and replacing distribution and transmission infrastructure.
So I'm getting at, was there a time in fairly recent history that, or during your time in the business, that the pace of the increase in the cost was slower than what we see today?
I think when I first started, and I first started at Carolina Power and Light, and you had the construction of some large nuclear facilities, and the utility was growing into that capacity. So there was a period of time where new generating capacity was not needed. We are no longer in that era. We are seeing tremendous load growth, needing to replace an aging fleet, and we're transitioning to cleaner energy.
So when you look at moving from era to era, would you agree that there are pockets or segments or classes of customers that aren't accustomed to seeing this kind of pace in the increase of the cost?
I'm sure there could be.
That there's a fairly, in North Carolina, there's a fairly sizable group of customers who are used to a slower pace in the increase of the cost. Do you foresee any, as you look out over the horizon, way out, can be way out, could be nearby, but do you see that pace coming to any kind of slowdown? What can the customers reasonably expect?
Well, as I look ahead, the policy of the state is for us to achieve carbon reduction goals, which I think are beneficial to all customers. That is going to require significant amounts of infrastructure to get us there. I'd like to think that we can do it at the right pace and the right mix, so as that we can continue to keep rates affordable for our customers.
And hopefully after we achieve a net zero carbon emissions reduction by 2050, let's say we have achieved that and we're celebrating that. Would you expect after then possibly? And I know this is I admit this is speculative, but I'm just trying to see where we think the industry is going. If you have any idea, do you think possibly we might see slowdown?
I think possibly. I mean, we have so many technology advancements. They're advancing every day. I'm optimistic somebody's going to solve this and come up with, at Duke Energy, we coined the term ZELFR, zero emitting load following resource. I'm optimistic something's going to get developed and help us with this going forward.
And that's a little bit where I was going. I was going to ask you, and I still will, what are the efforts, either by Duke or the industry, to actually either reduce or slow down the increase of the cost of doing business? Can we see returning to a time when this pace of increase might reduce? And due to technologies or research or other efforts, are there efforts like that you know about?
Well, I know there's a lot of efforts underway. If you look at the Infrastructure Investment Jobs Act, there's a lot of work. Duke Energy is partnering with the Southeast Hydrogen Hub, looking at the viability of hydrogen to be able to reduce carbon and to be able to create that hydrogen when you're in those periods of excess solar. For example, when you've got one of those beautiful Carolina blue days and you don't have enough load, but the solar is really going gangbusters, could you create hydrogen? We're doing a lot of research in that. I know there's a lot of great research going on with battery technology, a lot of research on nuclear, advanced nuclear, small modular nuclear reactors. I think there's a lot of research out there happening. And so I'm optimistic.
With the idea because that research itself is going to add some cost at some point, but ultimately
yes, but
these
the
things
ultimate goal
will have a cost impact that's more favorable. I ask these questions because affordability is always tends to be more heavily focused on on rate reduction. But I think a key to getting to that is to get the cost of the service down wherever and however we can and still have reliable service and that kind of thing. So thanks for indulging me.
You're welcome. Commissioner Plattfelter.
Ms. Bowman, good morning. I want to pick up on something that Mr. Josie asked you about and carry forward with it just a little bit, mainly so that I can try to get a sense of how all the different parts are going to fit together to add up. And I think he asked you a question, the gist of your answer being that not all of the company's planned capital spend over the period of the next 3 years is included in the multi-year rate plan filing.
Correct.
Yeah, I understood him correctly. I understood your answer correctly, right? So that it's a question I've been sort of thinking through too, is how do all of those things fit together? How does what's in the plan and what's not in the plan fit together. What's not in the plan will show up, I assume, in some future general rate case. It'll be plant in service, and it'll be brought in for inclusion in base rates in some future general rate case. So, but still, I'm juggling a lot of the pieces. So as I understand the statute we've got on multi-year rate plans, you can't put a capital spending item in the plan unless you're pretty sure it's going to be, you're not certain, but you're pretty sure it's going to be used and useful in the rate year in which it goes into the plan, into rates, right?
That's correct.
So the company selected projects for this multi-year rate plan that it had some reasonable expectation it would be able to put in service in year 1, year 2, and year 3. Correct.
Correct.
And if you didn't think the project was going to be in service in one of those 3 years, that's the other bucket of capital spend. That's the capital spend that's outside the multi-year rate plan.
Correct. Or it could be, if you have a project that's larger than 500 million,
Right.
you can't put it in. Or if you have, new federal law, for example, comes down where I've got to make some kind of investment, you save that for your next base rate case.
Thank you. A new generating facility that's more than $500 million, the statute says you can ask for separate treatment of that.
Right.
Law changes, I understand. What other reasons would what other reasons would you keep something out of the multi-year rate plan or have to keep it out? Either decide to keep it out in your choice or you had to keep it out. What would be the other reasons?
Ms. Bateman might be able to answer this question better than I.
All right.
So if you could potentially hold that for her.
She's sitting back there and she's heard the question, so I'm sure she'll be prepared with a good answer. Well, here's what I'm getting to, and I'll ask you too, and if you want to defer the question, but you're first up. You're the head of the operation, so you get the first question. So I look at what's in the multi-year rate plan, and I'm struck by something, is that a lot of the things I don't see are capital spending items that are directly called for in the near term, that is in the next 3 years, by the carbon plan. I'll give you an example. It's just an example. It's not exhaustive, but it's just an example. So in the carbon plan, the company tells us, and the commission accepted this, that the company is going to have to make considerable capital investment in its existing gas generation fleet in order to make the fleet more flexible in operations and therefore be better able to balance and respond to the addition of intermittent resources. That was not quantified in the capital plan filing. The amount of that capital spend, the projects were not identified. We don't know much detail about it from the carbon plan itself. I look at the multi-year rate plan, and I don't see any of that. Should I conclude from that that means it's not going to happen in the next 3 years?
No.
What should I conclude? What kind of conclusion can I draw?
It's coming, but there are investments in the multi-year rate plan that are correlated to the carbon plan.
And some of those I can see. I'm
Yes.
sorry, I apologize for interrupting you. Some of those I can see. I'm asking really more for you to help me about the ones that I don't see. The things I see in the carbon plan that the company has said and the commission has agreed need to happen in the near term. I mean, near term, not wait until 2027, 2028, but now. What kinds of things should I conclude about the fact that I don't see some of those things?
Well, some of those that
Help me.
we have to come before you to get a certificate of public convenience and necessity.
Okay.
So you will likely see those in the coming months. So I think from a timing standpoint, certain things have to happen before you see those in a projection.
All right, that's fair. I think what the question is. I'm just trying to fit all the pieces together to be sure I know how the pieces that are in the multi-year rate plan fit with everything else that's going on, and to make sure there are no gaps. So I'll leave you alone on that. I think Ms. Bateman's heard it. If she can elaborate, I'm perfectly happy with that too. Thank you.
Thank you.
All right, Commissioner Duffley.
Good morning. Congratulations on your new position. So I wanted to follow up on something that Ms. Kress asked you about, and it's this, the eligibility for customer assistant type programs. And she asked questions about the 100% of poverty levels and the 200% of poverty level for eligibility for each of these programs. So I'm just seeking clarification, and maybe it's for Witness Harris, but could you give clarification as to what the eligibility criteria is for each of your assistance programs?
So I'll address that, if you don't mind. So it does vary by program. I mean, most of these programs that we are referring to are state-run programs. And so the eligibility requirements are deemed by those agencies. So I've seen anything from the 130% that was mentioned earlier to 200% of at the federal poverty guidelines.
Okay, and can you point me to the testimony to where I can see what the eligibility criteria is for each of the different programs?
I don't think we have all the criteria for all the programs in my testimony, in my direct testimony.
Okay, should I ask this question of Witness Harris or on rebuttal testimony?
We'll have that answer for you on the affordability panel.
Okay, thank you. And then I was also seeking clarification of the Share the Light fund and how it relates to the Energy Neighbor Fund, as well as I think the DEC is Share the Warmth Fund. Is this a replacement of those two funds? Okay.
Yes, so the Share Light Fund, our program is our new rebranded program that replaced those programs. So yes.
Okay, thank you. And then with this will be with Ms. Bowman's testimony on page 20, you talk about the investment tax credits. And in the settlement testimony with public staff, there is the request to set up a deferral account. And so what witness can I speak with about the current status of these investment tax credits, whether the company is going to be providing updates before the next rate case, and then if and how the deferral, if it is granted, would be dealt with in the next rate case, being amortization or a flowback rider. What witness would be the appropriate witness to discuss those issues?
I think it's either Bateman or Abernathy. One of our rates witnesses could address that. And, we will obviously update the commission on the status of all of that, as well as the IIJA. I think there's a docket now where we file updates regarding our status of that as well.
Okay, thank you. And then one more question, going back to Ms. Quick, about how is the foundation funded?
Yeah, so the foundation, in this example where the foundation matches up to $375,000, those are shareholder funds.
Okay, thank you. Nothing further.
All right. Let's see, we got Commissioner Hughes.
Thank you. Do either of you have a very specific example where the modernized rate construct leads to you being able to lower your revenue requirements compared to the old rate construct? I understand a lot of rate benefits of, leveling and things like that, but is there any example where the modernized rate construct actually lowers what you have to ask customers to pay compared to the old? Wish I had a snazzier name. I like modernized rate construct, but the old, the old rate construct.
I hate to keep punting everything to Witness Bateman, but I think Witness Bateman might, one of the benefits is you have less frequent rate cases. And rate cases come at a cost and time. And so this construct hopefully will stay out for 3 years. I know that that's one thing. Another benefit is it does provide some kind of certainty in terms of rates. But I'll defer to Witness Bateman. She might have more granularity than I have.
Okay, thank you, but I appreciate the answer about the rate case. So that is a something that could be pointed to the customers. I'll defer or ask her that as well. Thanks.
Just one or two questions, and it may be may appropriate to address them to the affordability panel when they come up. But I guess my questions are addressed to Ms. Quick. I know in your testimony you talk about the customer assistance program and how it was tailored and that it came out of the recommendations of the Low Income Affordability Collaborative. Is that correct?
Yes.
All right. Now, in structuring the program, it's structured different than what the recommendation was coming out of the Low Income Affordability Collaborative. And I'm thinking about finding number 24, which is referred to from time to time, in testimony coming from Duke and from interveners in this case.
So there were several recommendations that came out of the LIAC, and Witness Barnes is an expert in all those recommendations, and she's part of the affordability panel. So I think those questions would be better addressed by her.
Better addressed by her. Okay. And I believe in your testimony, you say that, it's best to come up with programs that are uniquely structured to help out, particular income groups or peoples. Is that correct?
Well, what I would say is that through our affordability ecosystem, we are trying to support and help our customers who are in need of assistance, whether it's reducing their energy usage through our energy efficiency programs, our weatherization programs, whether it's through our bill and payment assistance programs with our budget bill program, installment plans, pick your own due date, et cetera. But a third leg of our affordability ecosystem is really around assistance. And two recommendations that I put forth in my testimony is around the customer assistance program and payment navigator. So with all of those, we feel like we can better support our customers who are in need of assistance.
Okay. And I'll raise it now, and perhaps affordability panel can address it more specifically, but I know you talk about a one-size-fits-all approach is not necessarily the best approach to use, but it seems like the customer assistance program with the flat payment that goes to everybody is more or less one size fits all. So I guess the thing which if you can address it now, that'd be great. But if the panel can address it when they come up, is helping to explain to me why what has been proposed in terms of the flat $42 credit is not a one size fits all approach, notwithstanding the fact that you're looking at LIHEAP and the SIP programs as pre-qualifiers, but I'd really like to hear more about that at the appropriate time. And I guess I would simply ask this question, maybe this is to Ms. Chirac. When do we expect this affordability panel to be coming for us?
The affordability panel is a rebuttal panel, and obviously it's somewhat difficult to forecast out how long it would be. We're optimistic that we can continue to shorten. So I would hazard it would be a very tentative guess, but I would say hopefully towards the end of next week would be when they would be scheduled to appear. We're certainly open if the commission needs to move witnesses around. We can certainly accommodate any requests in that respect.
Very good. Is there anything you'd like to say, Ms. Quick, in connection with that inquiry?
Well, I would just say, as an outcome of the Low Income Collaborative, this is a cross-stakeholder process that involved the company, external stakeholders, et cetera, working together really every 12 months. And so as an outcome of that, the company is proposing this, and we do feel like it will help our customers who are in need and who are qualified or deemed eligible for LIHEAP and SIP funds. And so it helps a mass group of customers who need assistance.
Thank you.
Commissioner Kimwright? All right. Just a few questions for you all. I'm going to start with Payment Navigator. Ms. Quick, can you talk some about the genesis for that program?
Yeah, so Payment Navigator, as a strategy, is really a group of specialists that, experienced specialists that we would put to support our affordability ecosystem for our customers. And so those specialists would be trained to really understand the customer's needs, because the customers we're thinking about actually being driven to the Payment Navigator are those that have a disconnect notice in their hand. And so it's really taking the time to sit down, have a discussion with those customers, and figure out how we can tailor their needs so that they can avoid disconnection for non-payment. We did pilot this during the pandemic, and we took an outreach approach. We partnered with one of our local agencies in Charlotte in particular, and we reached out to customers who were in arrears, and we knew that they would be potentially up for disconnection for non-payment soon. And we said, hey, we think you may be eligible for these assistance funds, partnering with this agency. And we found a lot of success in that program, and that's part of this whole Payment Navigator concept. We surveyed those customers. Believe it or not, 50% of those customers weren't even aware of assistance available. And of course, given the pandemic nature, a lot of our customers, one of the comments that I read, the customer's spouse had passed away. And so he was down to a single income. And had we not reached out to him, he wouldn't have known that that assistance was available in getting them to the Payment Navigator specialist and really connecting him with the agency. So twofold, really good thing for the customers. And at the end of the day, that agency actually ran out of funds. And so we're not leaving funds on the tables that our customers are not receiving. So that's kind of the whole concept and proposal here around Payment Navigator.
Okay, so had it been the case in previous years that funds held by the agency for the purposes of customer assistance had gone unused?
I would say yes.
Okay.
I mean, and that does happen, yes.
Okay. And what was it about, were there circumstances that the company was having to address or confronted with during the pandemic that gave you all the idea or sort of pushed you into initiating this program?
We've seen it initiated at another utility too. And so we thought, hey, now's the best time to actually test this out and see if it works for our customers. And it did. I mean, there was more assistance handed out to our customers, given this partnership with the agencies too.
The way I understand your testimony is that the specialists that are involved in this program, the company specialists, spend additional time with a customer and can direct the customer to certain types of assistance that the customer may be eligible for. And what I'm also hearing you say is that during the pilot phase, you all were proactive and contacted customers that you knew to be in trouble. Do you anticipate, well, first, make sure, do I understand your testimony correctly?
Yes.
Okay. Do you anticipate going forward that you all will be proactive in reaching out to customers that are in trouble or likely to be in trouble?
Yeah, I mean, we do that anyway as part of our overall communications and outreach to customers around assistance available, whether it's share the light funds, et cetera. We also have a website that, customers can go to and see all of our assistance available. So, we'll continue to do that. The unique nature of Payment Navigator in particular is these outreach communications can drive the customer back into a Payment Navigator specialist at the company who can take the time to really work with them on the solution that they may need. I mean, one example is, they may need help understanding the application and a question in the application that may have prevented them from applying in the past. And so this navigator can sit down and say, all right, this is all the information you need, and make it easier for the customer.
Okay. And you mentioned the organization in Charlotte, I assume, that you all piloted with, but are you also working with the government agencies that would provide public support to customers that qualify?
Yes.
Okay. Okay, and so the idea in this case is, or the request in this case is that you all be approved to expand this program on a full-time basis to the DEP customers.
Yes.
Okay. Okay. Ms. Bowman, thank you, Ms. Quick, for your, and Ms. Quick, congratulations to you for this being your first time in the witness stand. I think am I right about that?
Yes,
Well,
thank you.
welcome to the witness stand. Ms. Bowman, yeah. Ms. Bowman, Commissioner Brown-Bland asked you some questions about the environment we're in terms of sort of cost increases and some macroeconomic trends that we're experiencing right now, as well as sort of state of the company's investments and infrastructure. And you responded to her questions, and I heard your responses. And I think she also asked you about, how do we, isn't it the case that if we, that all customers are well served by the companies, minimizing costs and increases? And I think that you responded in the affirmative to that question. My question for you is sort of looking into the future in this environment that we're in, where the company is in the position of having to make investments to replace aged infrastructure and aged assets and invest in new types of assets. Is confirm for me that the company is committed to using every type of analytical tool available to the company to make sure those investments come on in a way that reduce system average costs, meaning they come on in a way that optimally sort of make sure that cost increases that customers are asked to bear are as low as possible.
I will commit to you, and it's actually our statutory obligation. If you look at 951, as we are pulling together our CPIRP, our next carbon plan, integrated resource plan, we are definitely looking to try to optimize every resource. Least cost is at the top of the list. So there's reliability and least cost, and we have to continually balance those together.
And you spoke about the success that North Carolina in particular has had in recent years with respect to economic development. And with that economic development comes load growth that the company has to address. My expectation would be that the company would address that load growth in a way that, again, optimizes, system assets for the entire system, ensures that system average costs remain as low as they possibly can. Is that the company's perspective?
That is our perspective.
Okay. Okay. We will go to Commissioner Brown-Bland. Go ahead.
Ms. Quick, I just wanted to follow up on Payment Navigator. Just one quick question. If we envision that program will all be run from a central location, or will there be community outreach where there may be, these navigators may be located geographically in the territory?
Well, I guess what I will say is they're going to be call specialists. So they're going to be centrally located, I guess. But the other thing that I would also like to add on to that is that we established a agency team in 2021 that specifically works directly with our agencies on getting pledges to our customers' accounts. And that group of folks are really responsible with building the relationships with our agencies out in the community.
All right. So, and then the pilot that was in Charlotte, that was primarily operated by phone call outreach.
Yeah, outbound text, outbound communication. So it was outbound calls, texts, and emails that were driven back into this group of call specialists that could help them kind of navigate avoiding disconnection for non-payment.
All right. Thank you.
Okay. At this point, we will begin questions on commissioners' questions. I would like to take a break for lunch at 12:15. I'm just checking in with the court reporter right now to make sure she can. Okay. All right. So we will take questions on commission's questions. We will start this side of the room.
We don't have any questions, Chair Mitchell. Thank you.
Any questions, Mr. Josie?
Spelman, Robert Josie with the Public Staff again. You mentioned in response to, I believe it was Commissioner Hughes's question, that the PBR and multi-year rate plan will provide customers more certainty with their bill.
Yes, I believe I said for that aspect, yes.
Okay, but would you agree that there are other things that would, or that they wouldn't necessarily have certainty in their bill based off of their usage or other factors that are not included in this case, such as the fuel rider?
So more certainty in the base rates and the projected rates. You obviously have the other riders.
Okay, thank you.
All right, Mr. Durack.
No questions.
All right. Well, then we have come to our lunch break. We will be in recess until, let's go to 1:30. Go back on the record, please. Commission has one more question for the Duke witnesses. We will ask that question, see if there are questions on that question, and then we will move on from there. Commissioner Hughes.
Yeah, I just wanted to get clarification whether we've talked about 375 and 500,000. I've seen recent information that kind of insinuated 500,000. So I'm just a little confused about whether it's 375 or 500. Like as of today or as of yesterday, when hypothetically I might have gotten an email from Duke as a customer.
Okay, so the DEP North Carolina portion should be the 375,000. The 5,000 is the entire amount for Duke Energy Progress customers.
The 500,000.
Yes. So the
It includes
375
the
is
South Carolina
yeah, so the
customers.
yeah.
Okay.
Okay, questions on Commissioner Hughes' questions? Okay. All right. With that, Mr. Drack, I'll take a motion from you.
Yes, thanks. At this time, we just move, I think we had the one exhibit into the record.
All right, hearing no objection to that motion, it is allowed.
Thank you.
All right, you all may step down. Thank you very much for your testimony. Ooh, don't want that. Yeah, I should take notice. All right, Duke, you may call your next witness.
Chair Mitchell, Kiran Mehta for the company. And at this time, Duke Energy Progress would call witness Dr. Roger Morin to the stand.
All right, Dr. Morin, if you would just wait 1 minute, Mr. Mehta. I actually want to dispense with these motions to excuse witnesses so we can take care of business and hopefully get people back to work and otherwise out of this proceeding. All right, I have received motions. The commission has received motions to excuse the following DEP witnesses: Council Hill, LaRoche, Murray, Paniza, Ray, Strasburger, Stewart, Hunsicker, and Thompson and Shearer. Confirm that that is the universe of witnesses that you all wish to excuse at this point.
That is correct.
All right, that the motion to excuse the witnesses is allowed as to Council Hill, LaRoche, Murray, Paniza, Ray, Strasburger, Stewart, and Hunsicker, but not as to Thompson and Shearer. All right, the commission has received motions to excuse witnesses Blank and Reno from the Department of Defense. That motion is allowed. The commission has received motion to excuse witness Gorman by Sigfer 2. Motion is allowed. The commission has received a motion to excuse witness Tomzik by the Fayetteville Public Works Commission. The motion is allowed. The commission will rule on the public staff's motions at a later time. All right. With that, Mr. Morin, you may come on up. Dr. Morin, I'm sorry.
Chair, if I could take up an issue before this witness testifies. Apologize. This is Will Freeman for the public staff.
You may, Mr. Freeman.
On the witness list that's been circulated, Dr. Morin is identified as providing testimony today for direct and rebuttal, which I appreciate the efficiency that gives us. But time is reserved for a second rebuttal, and I object to him rebutting twice.
All right, Mr. Freeman. Mr. Jurack.
We're not making that request this time, as we don't think this issue needs to be resolved this time.
Okay. Well, I will note your objection and we will move on.
Thank you.
All right, Mr. Mehta, you may proceed with your witness. Actually, that's right. Raise your right. Did you need to be heard?
Going back to to excuse.
Let's identify yourself, please.
My apologies. Kurt Bain with Kroger. Kroger Harris here also filed a motion.
And remind me of your witnesses. Bieber.
Yeah.
It's only Bieber that you're okay. That motion is allowed.
Thank you.
All right. Thank you, Mr. Boehm, and my apologies. All right, Dr. Morin, I think we are finally ready for you. All right. Raise your right hand, please, sir. Do you left hand on the Bible? Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. All right, Mr. Mehta.
Thank you, Chair Mitchell. Dr. Morin, would you please state your name, title, and business address for the record?
My name is Roger Morin. My business address is Robinson College of Business, Georgia State University. Address is University Plaza, Atlanta, Georgia, 30303. And my title is Distinguished Professor of Finance for Regulated Industry and Emeritus Professor of Finance at the Center for the Study of Regulated Industry.
And by whom are you employed and in what capacity, Dr. Morin?
Emeritus Professor at Georgia State University's College of Business.
Dr. Morin, on October 6, 2022, did you pre-file or cause to be pre-filed in docket number E2 sub 1300 direct testimony consisting of 83 pages as well as appendices A and B and 9 exhibits to that testimony?
I did.
Were these appendices and exhibits prepared under your supervision and direction?
They were.
And are these appendices and exhibits true and correct to the best of your knowledge?
Yes, sir, they are.
Are there any corrections you need to make to your pre-filed direct testimony?
No.
If I were to ask you the same questions today under oath, would your answers be the same as those set forth in that pre-filed direct testimony?
Yes, they would.
On February 13th, 2023, Dr. Morin, did you pre-file or cause to be pre-filed in docket number E2 sub 1300 supplemental direct testimony consisting of 4 pages as well as 8 exhibits to that testimony?
Yes, sir, I did.
Were those exhibits prepared under your supervision and direction?
Yes, they were.
And are these exhibits true and correct to the best of your knowledge?
They are.
Are there any corrections you need to make to your pre-filed supplemental direct testimony?
None.
If I were to ask you the same questions today under oath, would your answers be the same as those set forth in the pre-filed supplemental direct testimony?
They would.
On April 14th, 2023, Dr. Morin, did you pre-file or cause to be pre-filed in docket number E2 sub 1300 rebuttal testimony consisting of 88 pages?
I did.
And on April 17th, 2023, did you pre-file or cause to be pre-filed in docket number E2 sub 1300 corrected rebuttal testimony, correcting an error on page 68, line 22 of your rebuttal testimony and including Morin rebuttal exhibit RAM-REB-1, which was inadvertently omitted from your rebuttal testimony?
Yes, sir, I did.
Was Morin rebuttal exhibit RAM-REB-1 prepared under your supervision and direction?
Yes, it was.
And is Morin rebuttal exhibit RAM-REB-1 true and correct to the best of your knowledge?
It is.
Are there any other corrections you need to make to your pre-filed rebuttal testimony?
No, sir.
If I were to ask you the same questions today under oath, would your answers as corrected be the same as those set forth in your pre-filed rebuttal testimony as corrected?
They would.
Chair Mitchell, I move that Dr. Morin's pre-filed testimony in docket number E2 sub 1300 as previously described and consisting of direct, including appendices A and B, supplemental and rebuttal as corrected testimony be entered into the record in this proceeding and that it be copied into the record as if given orally from the stand in this docket.
All right, Mr. Mehta, hearing no objection to your motion, the direct testimony of Dr. Morin consisting of 83 pages and 9 exhibits filed on October 6th, 2022, will be copied into the record as given orally from the stand. Those exhibits not yet accepted into evidence will be marked for identification as they were when pre-filed. Supplemental testimony filed on February 13th, 2023, consisting of 4 pages and updated exhibits 2 through 9 will be copied into the record as if given orally from the stand. Those exhibits will be marked for identification as they were when pre-filed, not yet accepted into evidence. Rebuttal testimony filed on April 14th, 2023, consisting of 88 pages, as corrected on April 17th, will be copied into the record as if given orally from the stand. That one exhibit to the corrected testimony will be marked for identification as it was when pre-filed. All right, with that, you may proceed with your witness.
Thank you, Chair Mitchell. One other preliminary matter. Dr. Moran, did you prepare a summary of your direct supplemental and rebuttal testimony that was filed, I believe, on May the 2nd, 2023?
I did.
And Chair Mitchell, I would also move that summary be put into the record.
All right.
As if read, although we're not doing that anymore, thankfully.
All right. The summary of Dr. Moran's testimony will be copied into the record as if given orally from the stand.
Chair Mitchell, the witness is now available for cross-examination. Any questions from the commission?
All right. Sigford, you are up.
Thank you, Chair Mitchell. I would just like to start by letting the commission know that the public, Sigford 2 joins the public staff in its objection for the second rebuttal. I understand we're not there yet, but just noted for the record at the appropriate time. Thank you. And beyond that, or with that, Sigford 2 will yield its cross time for this witness to the public staff and others. Thanks.
All right, thank you, Ms. Kress. I've been notified that the commercial group has no cross-examination for the witness, so then we will proceed to CUCA.
Thank you. Craig Schauer, I represent CUCA. Good afternoon, Dr. Moore.
Good afternoon to you. Glad to meet you, I think.
We're going to have fun.
Yeah, we will.
To calculate a fair return on Duke's equity, you used various methods to measure the expected returns of a large group of comparable companies. Am I right?
Yes, sir.
And the expected return for that comparable group of companies serves as a proxy for a fair return on Duke's equity?
That's correct, sir.
And after calculating the return of the proxy group, if DEP's risk profile were to differ from the proxy group, you would apply a subsequent risk adjustment to account for that difference in risk profile, right?
I would.
Right. And Exhibit RAM-2 identifies the 23 companies that you used for your proxy group. Is that right?
Yes.
Starting with your direct testimony, on page 70, you testified that you see a, quote, quantum increase in the risk complexion of the electric utility industry. Do you recall that testimony?
I sure do, yes.
And you recall that you identify 4 major challenges facing the industry as a whole.
That's correct.
Now, these challenges that the electric utility industry faces, these are not risks unique to DEP. They are common among the entire proxy group as well.
They are generic.
I'm going to transition to your rebuttal testimony now.
Okay.
You testify that performance-based regulation, and I'm starting on page 4 of your rebuttal testimony if you need to reference it. You testify that performance-based regulation and multi-year rate plans do not warrant a downward adjustment in DEP's return on equity. Is that right?
That is correct. There are many reasons for that.
And we'll get into those, won't we?
Okay.
On page 4 of your testimony, you explain that performance-based regulation and multi-year rate plans are types of risk mitigating mechanisms. Do you recall that terminology?
Yes, they are.
And you observe that while risk mitigating mechanisms reduce risk on an absolute basis, they do not necessarily reduce risk on a relative basis compared to the other utility companies.
That's correct, because the capital market data on the peer companies, bond ratings, stock prices, beta risk measures already reflect, impound the effect of these risk mitigators. So if we were to make an adjustment, we would be double counting. A good analogy would be a fuel adjustment clause. Let's say we make a downward adjustment because the company has a fuel adjustment clause, but all the other peer companies have a fuel adjustment clause. So we would be double counting again. It's the same argument.
But do you agree that DEP's PBR application, if granted, would reduce DEP's risk on an absolute basis?
Yes, I do.
Now, in addition to multi-year rate plans, your testimony identifies other types of risk mitigating mechanisms, correct?
Correct.
Right, and those include revenue coupling, riders, adjustment clauses, ROE incentive riders, forward test years, and cost recovery mechanisms. Are those all different types of?
And trackers.
And trackers, right? And then you explained, as you just did from the stand, that most electric utilities in the industry possess certain types of risk mitigators, such as the ones you identified in your testimony.
That is correct. Risk mitigators have become basically mainstream in the industry.
Of the 23 companies in your proxy group, which ones currently have a multi-year rate plan?
I didn't investigate that at all because I assumed all these companies are operating in states that have all of these myriad risk mitigators.
Okay, but you don't know which companies in your proxy group actually have multi-year rate plans?
I do know that they all have risk mitigators, but I don't know the magnitude of each one in particular. I didn't need to know that.
So you also don't know which of the 23 companies in your proxy group currently has an earnings sharing mechanism?
I do not, but I do know they all have risk mitigating mechanisms, which all accomplish the same thing. They reduce regulatory lag, number one. And number two, they reduce what we call attrition, downward effect on earnings, for example.
So are all risk mitigating mechanisms created the same?
No, they're all different. They look at things a little differently, but they all accomplish the same goal.
But they would also all have different impacts on the company's risk.
No, they don't actually, because we've had a lot of empirical studies that have been done on the impact of risk mitigators on ROE. And the inevitable result of those studies is that there's no impact, no discernible impact on the cost of equity, because these risk mitigators are simply offsets to the new risks that have appeared on the horizon in the electric utility industry. So we're back, essentially, these risk mitigators bring us back to the status quo of risk. Okay.
So when you mentioned empirical studies, you're discussing the Brattle study, I believe, which you cite at page 5 of your rebuttal testimony.
That's one of them, yes, sir.
Now, the Brattle study concluded there was an undetectable effect on the risk and cost of capital for a particular risk mitigating mechanism, didn't it?
For decoupling.
All right, so it didn't study other risk mitigating mechanisms.
No, but these other mechanisms accomplish the same goal. They reduce regulatory lag and they reduce risk on an absolute basis, not on the relative basis.
But do you cite any other empirical studies in terms of the lack of effect of risk mitigators in terms of a
Not in
company's
my
risk?
testimony, but there is one I just became aware of recently. You want to know what it is?
But it's not in your testimony?
No. Oh, okay.
No. No further questions.
Thank you, sir.
Thank you.
Right. Department of Defense,
May I approach the witness to provide the hearing notebook?
you may.
If I can find it.
Very sorry. Yeah, wasn't my fault. Very sorry. I'm ready.
Good afternoon, Dr. Morin.
Good afternoon, sir.
I'd like to direct you to page 24 of your direct testimony on lines 3 and 4. I'll give you a minute to get there.
Council to our groups.
I'm sorry about that. My name is Kyle Smith for the United States Department of Defense and all other federal executive agencies, and I would ask permission to refer to my client as DoD FEA for the remainder of the hearing to eliminate the need to say that long statement of the name.
You may.
Thank you.
I have it, sir.
Great. And you state that you use the dividend yields reported on the value line investment analyzer, correct, in implementing your DCF model?
Yes.
And are you aware that the value line bases those dividend yields on spot prices for a given day?
Yes, they are.
Do you recall the date of the spot prices used in your direct testimony?
No. I'm looking at the exhibit 3 and 4. The original direct testimony was based on 7/2022, no exact date. But I try to use spot, what we call spot current prices. And the reason for that is very logical. It's called market efficiency. The stock price at any given time reflects all that's knowable about a market. The markets are pretty efficient. If you go back in time, it's becoming stale. You're missing information. So the answer to your question is we're using as current as possible stock price.
And you said the date was 7/20/2022. Is that right?
Yeah, in the direct. And then, of course, in the update, much more recent data was used.
And that's my next question. What was the date used when retrieving the same data for your supplemental direct testimony?
If you look at the supplemental exhibits, the date, again, it's a month, but well, actually, it's an exact date, 11/19/2022. And some will say, well, there's some vagaries, you know, the stock prices may be anomalous, but when we're using a large group of utilities, these potential anomalies cancel each other out. So
Is it fair to say that stock prices of any given company fluctuate from day to day?
it sure is, yes.
So why wouldn't it be better to use an average of, say, over a 30-day period or some average over a period?
The further in time you go back, the staler the stock price becomes, the less information is embodied in the backward-looking share price. So market efficiency requires the use of current prices so that because the current price reflects all the information that's relevant at this point in time. Now, I think you're suggesting, yeah, there's variability in stock price. That is true. You're right. But if you're using 22 companies, these vagaries of individual stock prices will cancel each other out anyway. So we're in pretty good shape with the 22 companies.
Okay. But why wouldn't it be better to take a current average, not going back in time, but if the market's fluctuating on a day-to-day basis, you could be capturing a downward turn or an upward turn in the market if you're just using a single day. Is that correct?
Yeah, you could be, yes.
Okay, thank you. And I'm going to move on to the next topic, which is somewhat related, because I want you to go to your exhibit supplemental 3.
I have it.
And there, for column 2, you're now using Zach's investment reports. Is that correct?
Yes, sir.
And that's taken from, it looks like November 19th, 2022. Is that correct?
Correct.
And why have you switched for this exhibit to using Zach's investments report for dividend yields when you were relying on value line in your direct testimony?
No, wait a minute.
Am I incorrect?
Yeah, you're not correct. There are two exhibits. Page 1 uses value line forecast and page 2 uses analyst forecast. So I did look at value line in the direct testimony. And over here, we're looking at Zach's and value line.
Okay.
Yeah. And Zach's is pretty good because they got so many analysts that report their forecasts. So
okay,
it's more reliable.
And could you explain why for your column 2 using Zach's in supplemental 3 you're using an 11/19 date, and then in supplemental 4 you're using an 11/17/2022 date?
Well, the 2 days doesn't make any difference.
Okay, so there's no reason.
No,
it
there's
just
no
doesn't
reason.
matter.
No, just at the time of preparing the exhibit.
Okay. Thank you. Now I want to go and direct your attention to more indirect at page 56.
Have it.
You were quicker than me. So in your historical risk premium estimate, is it correct that you're using a proxy group of 30 companies listed in the Standard & Poor's Utility Index to estimate the risk?
That is correct. The risk premium analysis was indeed performed on a broad index of utility companies, namely the S&P Utility Index, which has 30 companies.
Okay.
And I felt pretty good about that because I look at the betas of these companies, they're like 0.89, and my sample beta is about the same, 0.89. So I felt that they were pretty comparable in risk.
So now I want you to look at the notebook that I gave you.
Okay.
And reference DOD FEA potential cross exhibit 1. And I may need help naming this for admission, because I think please correct me if I'm wrong, but this would be DOD FEA Morin direct and rebuttal exhibit 1 or cross exhibit 1, excuse me.
So, yeah, well, almost.
The potential cross, not direct exhibit.
All right, let's make sure the witness has the right exhibit first.
Okay. I have it.
All right, so DOD, the exhibit will be marked for identification as DOD FEA, cross-examination, Morin, direct and rebuttal, exhibit 1.
I have it.
As well. And is this the list of the companies that make up the S&P 500 utility index?
Yes, sir.
And is it true that some of these companies would violate the criteria used when you chose the companies for your proxy group used in the DCF and CAPM analysis?
Yes, that is correct. Some of these companies are not vertically integrated utilities. The index here reports or includes some companies that are T&D or transmission and distribution only. And I wanted to focus only on vertically integrated electric utilities like Duke Energy.
And this list also includes the parent company of Duke Energy Progress, correct? Duke Energy Corp.
That is correct. You cannot perform any kind of analysis on the subsidiary because there's no stock price, there's no beta, there's no data. So you have to perform the analysis on a parent company.
And it also, and I'm speaking to the S&P 500 utility index. It also includes Pacific Gas and Electric Company.
Yes, it does.
And you eliminated that company from your proxy group. Is that...
Oh, PG&E had to be eliminated because it doesn't pay dividends. So it wouldn't fit the DCF model. You can't use the DCF model. The company doesn't pay any dividends. So PG&E was eliminated indeed.
And it also includes Pinnacle West Capital, and that was eliminated from your proxy group.
Correct.
And this list also includes companies in other utility sectors as well. Is that correct?
It does, but I checked for that and I looked at the so-called beta risk measures, and the average beta for the group is identical to the average beta of my proxy group. So I felt pretty good about the validity of this S&P group for that risk premium analysis.
Okay, thank you. At this time, I'd like to move this exhibit into the record.
Let's hold on that motion and I'll take motions from you all when it's time for this witness to step down.
Okay, thank you. And now I want to go touch on something that you've already briefly addressed. And that's in relation to the risk reduction that you discussed and potential double counting. Do you remember discussing that?
Yes, I do.
And I think you said that you weren't aware of whether the companies in your proxy group had performance-based rate making. Is that correct?
All of them have risk mitigators. Some of them have decoupling, some of them have MYRP, some of them have PBR. They all have one thing in common. They all have risk mitigators, which all accomplish really the same thing to reduce or even eliminate the regulatory lag and eliminate some of the volatility in revenues. So they all have that in common.
But I think you also said that they're all not created equal. Is that correct?
Yeah, there are some subtle differences between the details. You know, the devil is in the detail. For example, some of them will have a sharing mechanism which works both ways, on the downside and the upside. Others will have just sharing on the upside. Another example would be the width of the band, ROE bands, at 200 basis points or 100. They all have these subtle differences, but they all accomplish the same goal.
Is it fair to say that some of them have greater risk reduction than others?
Yes, it would be fair. For example, if you have a sharing mechanism where you share over earning on the upside, but you don't share on the downside, that's asymmetric. That's heads I win, tails you lose kind of situation. So that would be one example of a subtle difference.
Would it be fair to say that something like performance-based rate making reduces risk to the company greater than, say, a fuel adjustment clause?
I'm not sure I could quantify that. If anybody could quantify that, investors tend to look at do we have risk mitigators or don't we have risk mitigators? They don't really drill it down to the extreme detail of the minutia of the particular plan. The bond rating agency, they say, oh, this commission is very supportive. They have risk mitigators in place, and the bond rating reflects that. So does the stock price. They don't go into all the minutia of the details. We couldn't quantify that even if we tried. Besides, it doesn't have any impact anyway because it's already in the stock price.
It's correct that nearly, I think, every vertically integrated utility has a fuel cost recovery rider. Is that correct?
That's a good example, actually. And if we wanted to reduce the ROE because the company has a fuel adjustment clause, that would be inappropriate because all the other peer companies also have the fuel adjustment clause. It's exactly the same analogy as my risk mitigators example.
But not every vertically integrated utility has PBR, correct?
No, but they have something very similar. They might have CWIP and rate base. They might have a decoupling mechanism. They might have a PIM regime.
I want to reference DoD FEA potential cross exhibit 2. Again, I'm probably going to mess this up. So this should be marked as DoD FEA cross exhibit Newland direct and rebuttal. Morin direct and rebuttal.
All right, the document will be marked as DoD FEA cross-examination, Morin direct and rebuttal, exhibit number 2.
And that's an excerpt from the quarterly state regulatory evaluations.
I have it, yes.
Let me get to it. I'm seeing pages that. And do you agree that this shows that only 21 states have PBR?
What page are you on?
I'm trying to find the same thing. I believe that it is.
I think you're referring to generically to alternative regulation plans, not PBR specifically.
Yes.
So, yeah, okay, so we're on the same page, literally.
So is that correct?
Yes, they all have, this, yeah, this table on page 5 of 6 shows all the various regimes of risk mitigators and which states have which. Under PBR, it doesn't specifically say PBR. It talks about formula rate making, multi-year rate making, earnings sharing, incentive ROEs, etc. And it lists the states that have these regimes. So it's pretty widespread.
But still less than half of the states, correct?
Well, I have to count them, but
Subject to check. If I tell you
Yeah.
it's 21, you would agree that that's less than half of 50.
that have what now?
If I, subject to check, if I tell you that it's 21 states, that's less than half of 50 states, correct?
That have what?
These alternative or formula-based multi-year rate plans, these
Okay.
alternative rate making processes.
Yes. As of 2-3 years ago, yes. Lots happened since. I also noticed in the same exhibit that the North Carolina Commission looks really, really good here. It's supportive. They have a very good reputation with investors.
Chair Mitchell, I'm just eyeballing this list. It seems like more than 21 to me, but I haven't counted them. So I'm not quite sure if this is the list on page 5 of 6. I'm not quite sure what exactly Mr. Smith is asking about.
Mr. Smith, if you would, look at page 5 of 6, Mr.
Yes.
Met is referring to, and ask your question again of the witness so that the question is clear and he can be sure to answer the question that you're asking.
I was specifically looking at the multi-year rate plans column, which I believe is 21.
Okay. That's page 5.
Yes, on page 5 of 6.
Yeah. Okay.
Does that clarify it, or do I need to re-ask?
Re-ask the question, just so we've got it in the record.
Would you agree that there are 21 states listed on page 5 of 6 of this exhibit showing they have adopted multi-year rate plans?
I would agree with that. But, a heck of a lot more states have adopted comparable risk mitigators if you look at the whole table. But yes, I agree with you.
And that 21 states that have adopted multi-year rate plans is less than half of the states. Is that correct?
That's correct. But just about everybody in the country has some kind of risk mitigators, as this table shows.
Now, I'd like you to look at your rebuttal testimony and also to go back to something you mentioned in response to other cross questions from another attorney related to new risks on the horizon for public utilities.
Correct.
Could you expound on that? What type of new risks are on the horizon
Okay.
for companies like Duke Energy Progress?
In my direct testimony, I refer to the state of the electric utility industry as the perfect storm. And what I meant by that is that everything is changing in terms of risk profiles. And to be more specific, what I mean by that is, for example, how do you comply with the renewable standards? How do you solve the problems of integrating the transmission grid with the new technologies, for example? How do you deal with the threat, the specter of distributed generation, which can actually bypass the utility? This is a huge business risk in my view. And so those are 3 examples right there. And if you look at the data, there's a graph that absolutely astounded me in my direct testimony. I've been doing this for a long, long, long time. And the average beta of the electric utility industry in the last 5 years has been 0.6, 0.7, 0.8, 0.7, 0.6, which means that these electric utilities were about 60%, 70% as volatile as the market. You know where they are today? 0.9. Utilities are catching up to industrials in terms of risk profile. And that really surprised me. And that's sort of the proof in the pudding that these risks have intensified over the last decade or so. Does that answer the question, or?
I believe so. I mean, you're the one that's answering it. If you feel it does, then sure.
Well, I want to make sure you're happy.
Well, thank you. Do those risks provide any opportunities for utilities?
Yeah, I think they do. High risk, high returns, Yes, definitely some potential opportunities. And business plans are made to do this, to try to circumvent these barriers and try to, take advantage of these opportunities.
Do you agree that in a volatile market that utility stocks oftentimes are very attractive to investors?
That's a fair proposition. Traditionally, utility stocks used to be referred to as blue chips, widows and orphan stocks, but not anymore. As I said a minute ago, they've become a lot riskier than they used to be historically. But we do observe that in troubled times, in what I call black swan events like COVID, for example, the COVID crisis, you find that utility stocks provide a kind of a safety haven, so to speak, for a while, sort of a refuge, a temporary refuge, because you don't want to go in the stock market in these black swan eras. So the answer would be yes, but not as much as they used to in the past. They're not as blue as they were blue chips in the past.
I'd like you to look at DoD FEA potential cross exhibit 5.
I have it.
Which should be marked as DoD FEA Morin. Wait,
I'll get you. DOD, the document will be marked for identification as DoD FEA cross examination, Morin direct rebuttal number 3.
Thank you. And if you look at the
Figure 3.
Yes. Does that show that utility stocks have been outperforming the market in general by a fairly significant amount?
That was true until the end of the year, but if you do the same graph, you go on Yahoo Finance website and you draw exactly the same graph for this year, 2023, you see the opposite. The utility stocks have underperformed the stock market. It's been a sort of a very slight recovery in the S&P 500. Again, earnings reports are not as bad as they were expected to be. So that's true at that period of time, but not so much so in the first quarter of 2023.
And what is this document that we've marked?
Well, it's a report from Fidelity, I guess, investment firm.
And is this the type of information that you might look at in evaluating how investors feel about or what their outlook is on utility stocks?
That's a fair statement, yes. That's why I looked at it for the first quarter of 2023, and it showed the opposite.
And could you look at some of the key takeaways that this document lists?
Where are you?
That's on the first page of the document.
Oh, yes.
Do you see that it's discussing some of the challenges that the transition from fossil fuels to greener power and also away from gas to more electric based may have on this sector? Is that correct?
I think they could have some positive impact, but I noticed in those 4 bullets, the adjective could, may, could. And that suggests, risk to me. But yes, I don't have a problem with that at all.
Okay, so you would agree with
I would
with
agree that
these?
it could potentially, but that's risk. Not can, could.
Certain. Okay, these are projections, correct?
Yeah, yes.
All right, thank you. That's all the questions that I have.
Thank you, sir.
All right. Public staff, you were up. Oh, actually, I'm sorry, Mr. Neal. I'm
Chair
sorry.
Mitchell, may I approach? with my-
You may.
May I approach too? Just go ahead.
Please do.
Well, Mr. Neal says he has 90 minutes. You have plenty of time, Mr. Freeman.
You are too.
I've
Mr. Freeman.
Has 90 minutes and.
Oh,
Oh.
sorry.
Good afternoon. This is David Neal, representing NCJC et al. And I pride myself on keeping to my time estimates. We'll see if that pans out today.
Are you the 4-hour person?
No, sir.
Okay.
Maybe we can start off just making sure we're on the same page with some key terminology. Cost of capital, you would agree, refers to the return investors expect on their investment.
Yes, sir.
And cost of equity capital refers to investors' expected market return on their equity investment.
Yes, sir. I agree.
Now, and then return on equity is a percentage equal to net income divided by book value of equity.
Yes.
And you would agree that return on equity can be reported on a financial statement, correct?
I would agree.
Like value line, for example.
Yes, sir. I agree.
Cost of equity is not reported on a financial statement, isn't that right?
It has to be inferred and measured and implied using a bunch of models.
And finally, authorized rate of return refers to the amount of money expressed as a percentage that a utility is allowed to recover in customer rates to compensate debt and equity investors for assuming the risks of investing in the utility.
I agree. Well said.
And it's your testimony that the authorized rate of return on equity should be set to equal the cost of equity.
That's correct.
And if we could turn to tab 76.
Which book?
Yes, sir, you have the correct book. And if I could, Chair Mitchell, mark in tab 76 are excerpts from New Regulatory Finance, one of your books. We would ask it be marked NCJC et al. Cross-examination, more indirect rebuttal, Exhibit 1.
All right, the document will be marked as NCJC et al. Cross, Morin, direct rebuttal, exhibit number 1. It's
I have it.
Thank you. If you could turn to page 23, which as paginated in your book. Could you read for me the first sentence under section 1.8?
The regulator should set the allowed rate of return equal to the cost of capital so that the utility can achieve the optimal rate of investment at the minimum price to the ratepayers. This can be shown as follows, and there's some examples.
Yes, and you would agree that's your position in this case as well?
Yeah, yes, sir.
all right, Mr. Neal, before you go farther here, what page are you, look at the page number on the document. I'm looking at, for example, 276.
I'm looking at page number 23 of New Regulatory Finance. And it's the 13th page of the PDF, I've been informed.
Let's see. So it's, okay. So it's page 23 of the book.
Yes.
And it's 13 of the PDF. Okay. Are we all there? Okay. All right, proceed.
And turning to your direct testimony on page 73, and again, I'll read it to you. You testified on page 73 that right from the start, you wanted the commission, or you said you wanted to point out that the commission must balance the interests of investors and customers in setting the cost of equity. And a little further down, that the commission's task is to set rates as low as possible, consistent with the constitutions of the United States and North Carolina. Is that a fair summary of that part of your testimony?
I would agree with that.
And it's your testimony then that setting the allowed rate of return on equity at 10.4% is the lowest possible amount needed to meet those standards?
Yes, sir.
If you could turn to tab 57. And this is a
Any reason why you didn't use the most current version of the book?
If you could please turn to 57, and Chair Mitchell, we would ask that this data request response from DEP to public staff number 249-1 be marked as NCJC et al. Cross-examination, Morin direct rebuttal, Exhibit 2.
All right, the document will be marked as NCJC et al. Cross-examination, Morin, direct rebuttal, exhibit number 2.
All right. Have you gotten there?
Number 56, I have it. Is it 56?
57.
57.
Yeah, I have it. It's just one page.
It is one page. And you will see this was a data request from the public staff to the company. And you see where the public staff asked for a number of things from where you had testified or submitted testimony, including under A, the case number and docket number, C, your proposed capital structure, G, your recommended cost of equity, H, the cost of equity used by the commission, I, whether the capital structure, cost of debt, and or cost of equity were litigated or the result of a settlement. So you see the gist of the request.
Yes, I do.
And you would agree that the response from the company was that your exhibit RAM1 lists previous testimonies submitted by Dr. Morin by date and jurisdiction. And if you skip to the end, basically, that the burden of searching for and obtaining the information is substantially the same for public staff as for the company.
That's what it says.
And so you would agree, essentially, the company said, if you want it, go look for it yourself.
Well, there's over 200 cases that I've been involved in 40 years. I mean, obviously, I don't archive all of this. And it's available on public databases, on commission libraries, on commission data, commission orders, on the LexisNexis database.
And one of the sources you listed was Regulatory Research Associates. Isn't that right?
Yes, but they only go back to 1986.
So if you could now turn to tab 61, and we would ask that the documents under tab 61, which is a chart and an excerpt from RAM Exhibit 1, be marked as NCJC et al. Cross-examination, Morin direct rebuttal, Exhibit 3.
All right, the document will be marked as NCJC et al. Cross-examination, Morin, direct rebuttal, exhibit number 3.
And just to orient you, the excerpts from RAM Exhibit 1 are at the back of the exhibit, and we highlighted the state commissions where we could find your some of the information that was sought on in Exhibit 2 that we just talked about, and then pulled that information from Regulatory Research Associates, which is now part of S&P Global Market Intelligence. So do you see, are you oriented to the exhibit now?
Yes, I am.
Okay.
You cherry picked some cases.
And I, with all due respect, I picked the cases I could find on a very large spreadsheet of cases that went back, as you said, to several decades. and that I did not cherry pick. I picked all of the electric cases I could find from state commissions.
Okay.
And if you look at the blue shaded column, that's the return on equity that you recommended. Do you see that?
Yes.
And then if you look at the yellow shaded column, that's the commission authorized return on equity. Do you see that?
Yes. From 1981 until 2017. Okay.
And again, electric public utilities. Do you, with the exception of, and we're gonna talk about in a minute, a Hawaiian electric company, or HECO, is it HECO?
Yeah, HECO, Hawaiian Electric.
From 2004. In each instance, you would agree that your recommended ROE was higher than the commission approved ROE.
That's what the data shows.
Yeah. And for, as reported by Regulatory Research Associates in this 2004 case, they appear to be the same.
Yes.
Again, as you said, you've testified in a large number of cases. Do you happen to remember the ROE that you recommended in the HECO case in 2004 in docket number Hawaii Public Utilities Commission docket number 04-0113?
No, I do not.
Okay. Chair Mitchell, this is not going to be a cross exhibit. It's a commission order from Hawaii. If I could just ask the commission to take judicial notice of this order. And Public Utilities Commission of the State of Hawaii, docket number 04-0113, decision in order number 24171.
Chair Mitchell, I don't have any problem with the commission taking judicial notice of a publicly available commission order, even though from Hawaii or some other jurisdiction. But if Mr. Neal wanted to ask this witness about this document, it should have showed up on his potential cross list. And it, as far as I know, isn't, or is it?
Chair Mitchell, it is not in the cross because we don't need it as an exhibit and because I only thought to look for it today. But it's, again, I just want to ask one question.
Oh, Mr. Neal, we established the process for provision of cross-examination exhibits in advance. If I were to let you do this now, then I would be opening the door. I would have to allow all parties to do the same thing, and that would be contrary to the procedures that we set up at the outset.
And I totally understand, Chair Mitchell, but again, I'm not intending to offer as an exhibit. Counsel for Duke has said they don't object to taking judicial notice. If I just ask a question based off of what is publicly available information, Dr. Morgan can.
Well, Mr. Neal, if he wants to, can argue the document based on judicial notice, all he wants in his post-hearing filings. But one of the purposes of the, as I understand it, the mechanism that the commission has, I think, very properly employed is to give notice for the documents that could be used in cross-examination. And I don't have any notice of that particular document, whether it's an exhibit or not.
All right, Mr. Neal, we will take judicial notice of the document, and I will not allow you to use it as for cross-examination purposes. And Mr. Neal, before we move on, I want to be certain that the court reporter has the citation to the order. So would you please read it again and for the record?
It's the from the Public Utilities Commission of the State of Hawaii in docket number 04-0113. It is decision and order number 24171 from May 1st. This says filed May 1st, 2008.
Is that the one we asked for 10.7? The commission authorized 10.7?
All right, we're not going to, Dr. Morin, let's make sure he's got the citation correct. All right, and we will move on, Mr. Neal. Thank you.
So putting aside that case that we can point out in post-hearing brief what was requested, as we've established, the return on equity that you recommended was higher than was authorized in each one of these instances. Isn't that right?
In this particular sample, yes.
Yes. And
A lot of those cases are settled too, and there's a lot of variables that go into a settlement, so.
And you would anticipate that in those cases, like today, you would have argued to the commission that the return on equity that you put forward is the minimum amount required to comply with the constitutional standards we just talked about.
Yeah, it's the cost of equity.
And you don't have any evidence following the commission decisions that are listed here that any of those utilities were unable to access the capital markets, do you?
It's not so much a question of do you have access or not, it's at what price, under what conditions.
And following those commission decisions, setting the allowed ROE below your recommended amount, you don't have any evidence that the financial integrity of those utilities were compromised.
In either direction, I don't, going back to 1980.
As a general principle, you would agree that paying more for the exact same stream of cash flows necessarily means the expected return will be lower.
Yes, sir.
So as a simple example, if somebody paid $10 in exchange, $10 in exchange for a payment of $1 per year in perpetuity, assuming no growth, the return is $1 divided by 10 or 10%.
I agree with that. It's a perpetuity.
Mm-hmm. And if somebody paid $20 for the exact same stream of cash flows, their return would be 5%. Isn't that right?
That's correct.
And you would agree that same general principle would apply to stocks?
Yes, I would.
And in the case of bonds, you would agree that a similar principle applies. The price of an outstanding bond paying a fixed interest rate would drop when interest rates rise.
That's correct.
There's an inverse relationship.
That's correct. And vice versa. Yeah.
Now, as you would agree that investors in utilities base their cash flow expectations on the expected return on book value of a company?
No.
If I could point you to your direct at page 14, lines 1 through 4. Are you there? Well, you'll let me know when you're there.
I'm on page 14, lines 1 to 4.
Yes, and if you go back to the previous question, it's a question about how the fair rate of return is determined. The fair rate of return is determined. Yeah. And you see that your testimony includes the fair return in dollars is obtained by multiplying the rate of return set by the regulator by the utility's rate base. The rate base is essentially the net book value of the utility's plant and other assets used to provide utility service in a particular jurisdiction.
That's correct.
And it's also your testimony that investors base their return on equity expectations, at least in part, on the ROEs that regulators have authorized.
That's just one benchmark. Investors in stocks base their return requirements on the risks, something like beta, for example, or something like business volatility risk. So that's pretty simple stuff. I mean, they base their return requirements on the risks to which they're exposed.
Well, on page 60, you were asked about what investors take into account, or whether investors take into account allowed returns in formulating the return expectations. And your response is...
What page are we on?
Page 60. Of your direct, yes.
Investors do take into account a lot of factors, including recent allowed returns by regulators. That's just one benchmark. There are other factors like risk.
And you would agree that in its report's value line, list its return on equity expectations on allowed returns.
No, I do not.
Okay. If I could turn your attention to tab 60.
Oh, thank you.
And I guess we're at number 4.
I'm looking at it, Duke Energy, value line report.
So Chair Mitchell, I would ask that this value line report for Duke Energy be marked as NCJC et al. Cross-examination, more indirect rebuttal, Exhibit 4.
The document will be so marked.
And
Pull the microphone back down. Thank you.
if I could turn your attention, do you see, I've tried, since there's so much information here, I tried to highlight some things to make it easier. You see where it lists return on common equity in the middle of the right-hand column?
I do.
And there's a footnote E.
Yeah, I'm very familiar with
Yes.
that. So.
And then footnote, if you go down to footnote E, it says rate base, net original cost. And then it lists recently allowed ROEs from various commissions. Isn't that right?
Yeah, going back 21, 2019, 2020, yes.
And so you would agree that when Value Line is reporting on return on equity, it's considering recently approved ROEs.
They do consider that, yes.
Or commission allowed, authorized, same thing, right?
Yeah, but the ones you're citing are pretty stale.
Are you, well, put that to the side.
Stale, 21, 2019, that's stale. Inflation's up, interest rates are up. We see an increase in allowed returns now.
Well, and again, I'm asking how the information that Value Line says it uses in putting out its ROE estimate.
And one more caveat, this whole page applies to the parent company.
That's right.
Not the operating company.
No argument here. And you would agree that the way Value Line computes return on equity is by dividing earnings per share by book equity per share. Isn't that right?
Yes.
So for example, if we look at 2021, where Value Line reports 8.5% return on common equity, that's based off of the $5.24 earnings per share divided by $61.55, which is the book value per share.
Roughly, yes.
Which comes out to 8.5% subject to
yes.
tax.
And that's for the parent.
For the parent company, that's right. And you would agree that investors cannot buy Duke Energy stock at book value today?
Yes, I would agree with that.
And so an investor who's basing their return expectations, at least in part, on authorized ROEs, is considering the ratio of the book value to equity. Isn't that right?
No, the market determines the prices, the market to book ratio, based on a variety of things, including what industrials are offering, for example. What are comparable companies offering?
Right, but as we just established, the way Value Line reports ROEs and investors is, if they're considering ROEs as part of their decision-making, it's based off of a earnings per share by book value per share. We just established, correct?
Yeah, your question is sort of, you're living in an accounting world where you're looking at book values and accounting with divisors on and everything. Investors don't look at it that way. They look at it in terms of cash flows, in terms of the market price they have to pay for it today. That's what the DCF does. That's what the capital asset pricing model does. That's what the risk premium analysis does. So you got to remove the accounting visor and look at market realities.
And if we, but again, we've established that investors can't buy book value because they have to buy market value. We're clear on that, right?
We agree with that.
And if we go back to Exhibit 1, which is at tab 76, excerpts from your textbook.
I have it.
And if we go to page 359, and I'm sorry, I don't know what the PDF page that is. But it's under chapter 12. What's that? I've been, a little bird has told me PDF page 26.
I have it.
If you could just read for me In the middle of the page where it says in chapter 1.
In chapter 1, it was suggested that if regulators set the allowed rate of return equal to the cost of capital, the utilities earnings will be just sufficient to cover the claims of the bondholders and shareholders. No wealth transfer between ratepayers and shareholders will occur. So that basically in plain English says if you set the rate of return equal to the cost of capital, there's no wealth transfers between ratepayers and shareholders. If the commission was to set a higher rate of return than the cost, there'd be a transfer of wealth from ratepayers to investors, and conversely, if you set it below.
And if you could read the next, I think 2 or 3 sentences, I'll tell you when to stop.
Yeah, the direct financial consequences on setting the allowed return on equity equal to the cost of equity capital is that the share price is driven toward book value per share. The key part here is, at least in theory, under ideal conditions.
And then just the following sentence.
Intuitively, if R, meaning the return, is greater than the cost of capital and is expected to remain so, the market price will exceed book value. Want me to go on?
Yes.
But if R is less than the cost of capital K and is expected
I'm sorry to interrupt, but I don't think you finished that sentence. Expected to remain so, the market price will exceed book value
per share, since shareholders are obtaining a return in excess of their opportunity cost.
Okay.
But if R is less than the cost of capital and is expected to remain so, the market price will be below book value per share.
And I recognize in your rebuttal, you testified about Q ratios, which is the subject of this, part of the subject of this chapter. You would agree that you did not, in your direct or supplemental testimony, provide an estimate of cost of equity based on Q ratios, did you?
No, I did not. All I'm arguing in my testimony and in the book, and you failed to include those chapters, is if the Q ratio will be driven to 1. What does that mean in plain English? The Q ratio is the market value of the securities divided by the replacement cost, not the book equity, the replacement cost. And if the market value exceeds the replacement cost, they're all going to go ahead and replace, and the Q ratio will be driven to 1. If it's less than that, nobody's going to invest anything, and the Q ratio will be back up to 1. So it's not unusual for a market to book equity to be well in excess of 1, because it doesn't take into account replacement costs, inflation. And you kind of conveniently forgot that whole part of the chapter.
Professor Moore, you might have had, there might have been copyright problems if I put in your entire textbook as a potential cross exhibit.
I'll be glad to give you a copy of the new one.
If we turn now, you note in your exhibit RAM 9 that the growing spread between the riskless rate and allowed ROEs. Do you agree?
Mr. Neal, this is Kiran Mehta. Are we on rebuttal, not a rebuttal, supplemental exhibit 9 or direct?
I was on direct exhibit 9. I don't know that there's a difference, but if
there's no difference. I have it.
So you would agree that part of what this is reflecting is a widening trend or a widening spread between allowed ROEs and the risk-free rate?
Yeah,
and again, if I could ask questions, just that was a yes or no question. That's what this exhibit is showing.
It shows the relationship between the risk premium allowed by regulators with the level of interest rate.
And your risk premium analysis is based in part on the difference between the risk-free rate and allowed ROEs.
Correct. It's called the allowed risk premium.
And you recall that Mr. Ellis in his testimony also talked about this divergence between authorized returns on equity and the risk-free rate, starting at page 43 as originally filed.
Yes.
And you, recognizing you don't agree with his conclusion that authorized returns have exceeded the cost of capital, did you note on, or do you recall on page 45 where Mr. Ellis cited to an article in the journal Energy Policy by David Rode and Paul Fishbeck?
No, I don't recall.
Okay. So you're not familiar with the work of David Rode and Paul Fishbeck examining the increasing spread between ROEs and authorized returns?
Well, I'm very familiar with it. You're staring at the graph right here.
Right, I'm sorry, you're not familiar with their scholarship investigating this phenomenon.
I'm familiar with the facts, just the facts. There's an inverse relationship between allowed returns and the level of interest rates. When interest rates are very high, the risk premium widens. Why? Because regulators, they don't want to increase the rate of ROE as fast as interest rates. They want to slow it down, they want to moderate it a little bit. When interest rates go up, excuse me, the converse is true. If interest rates go way up, regulators are reluctant to assassinate the stock and increase the ROE equal to the increase in interest rate. There's a kind of a moderating factor here, and that's why you see this perfect negative line.
Well, and
that's the facts.
Right, and you would agree that the regulated equity premium back in the early 1980s, when interest rates were high, was much smaller than it is today.
Correct, sir.
And you would agree that the results of your historical risk premium method are necessarily influenced by that widening spread between the riskless rate and authorized ROEs.
That's correct. I'm looking at that graph down here and I'm saying, well, interest rates are going up, so the risk premium will probably shrink a little bit. Conversely, if interest rates start going back down again, which probably they won't, the risk premium allowed will widen.
And were you aware that the DC Circuit Court of Appeals rejected FERC's reliance on a risk premium model in setting authorized ROEs in its 2022 opinion, MISO Transmission Owners versus FERC?
Yeah, yes, I am. I was quite surprised by that because I spent 3 whole days with seminars and workshops at FERC. And one of my models was the risk premium. They adopted everything else, but not that particular model.
And so you're familiar with that opinion?
Yes.
And if I could direct you to tab 40.
I have it.
I don't. Okay. Chair Mitchell, we would ask, this is the opinion I just referenced. We would ask that it be marked as the next exhibit, which I guess is 5. So NCJC et al. Cross-examination, more indirect rebuttal, exhibit 5.
Document will be so marked.
And if we just go to page 27 of 30.
I have it.
And this is where the DC Circuit Court of Appeals summarized what a previous FERC order had found with regard to the risk premium analysis. And if you just look at the first bullet, you would agree that the court noted that the model, at least as applied in this case, quote, defies general financial logic by keeping the return stable regardless of capital market conditions. And they also found that there was insufficient evidence in the record to conclude that investors rely on this kind of risk premium model. And if you look at the last bullet, it presents particularly direct and acute circularity problems because it uses past FERC allowed returns to set new ones. So again, you recall, you are familiar with this ruling.
I'm very familiar with it and I disagree with most of it. But the risk premium technique is in all the textbooks of finance. It's widely used and it's published in all the mainstream university textbooks of finance. So I don't agree with that particular logic.
All right.
And
we're gonna
one more thing. It says it's not as accurate as the DCF, and I don't know where they get that from. There's no perfect model. That's why I use all of them. and triangulate the return based on DCF, based on CAPM, based on risk premium. And that way I'm reading all the instruments like a pilot flying an airplane on all the instruments. That's how I gauge what's in the investor's minds.
And turning to your rebuttal, page 26 and 27, you expressed, quote, serious concerns with table CCW 10 of Mr. Walters' testimony. I'll wait till you get there. Yeah.
Page 26, line.
This is where you testified that you had serious concerns with the references on table CCW 10 of Mr. Walters' testimony.
Yes, I see it.
Okay. And do you recall that CCW 10 table showed the expected return on United States large cap equities from 4 different investment firms: BlackRock Capital, JP Morgan Chase, Vanguard, and Research Affiliates?
I recall that vividly.
And you don't have any specific concerns with those forecasts beyond what you put in your rebuttal, isn't that right?
Well, buyer beware. Where do these numbers come from? Are they geometric returns? Are they arithmetic returns? Over what time period are they suggesting those returns? We just don't know. So buyer beware. And they themselves, in the italics on page 27, say, hey, look, be careful about those numbers.
But you would agree that companies like BlackRock or JP Morgan Chase, they've got hundreds, just more money than we can imagine invested, isn't that right?
Yes, they do.
And projected long-term growth rates are used by institutional investors to help determine their investment decisions, isn't that right?
Where are you?
I'm just asking if you agree that projected growth rates are used by institutional investors to determine the desirability of investing in different securities.
It is well known that analyst forecasts are the best sources of forecasts to use in the DCF model. And I'm talking about analyst forecasts over the next five years. But if you're referring to long-term forecasts of the economy 20 years from now, I don't agree at all.
And but capital market assumptions are a kind of forecast that investors could use to inform their investment decisions.
It could be, if they're correct.
And
it's interesting that it totally contradicts your value line expectations of 9.5 and 9. You said value line was great, so
Again, Dr. Moore, I'm not testifying. I'm asking a question.
Well, I'm just telling you, it doesn't match what you said earlier.
These, let's see. Well, you quote from one of these, so why don't we go there? Tab 64. Oh, no. I take it back. Give me 1 minute. '63. And this is an excerpt from the JP Morgan Chase long-term capital market assumptions report. And I would ask that it be marked NCJC et al. Cross-examination, more indirect rebuttal, Exhibit 6.
All right, the document will be so marked.
And if I just direct you to the second page is a forward from George Gatch, the CEO of Asset Management. And you see where he, in the second paragraph, right, kind of like maybe the third sentence, over the years, many investors and advisors have come to depend on our assumptions to inform their strategic asset allocation, build more resilient portfolios, and establish reasonable expectations for risks and returns over a 10 to 15-year time frame.
Yes.
And now the first concern that you listed in your rebuttal was that these expected large cap equity returns would suggest an even lower expected ROE for Duke Energy, a public utility, which is less risky than the overall equity market, in your words, somewhere in the 4.2 to 7.3% range. Do you recall that in your rebuttal?
Yeah, I'm looking at your exhibit on page 70. The bottom line, if you wish, under U.S. markets.
I'm sorry, Dr. Moore, where are you pointing?
I'm on page 70 of the exhibit you're
okay.
referring to, the last page, the U.S. market. And it says our expected return increases from 4.1 to 7.9. That's for the whole market. So how can a witness recommend something higher than that for a utility that's less risky? That's a big problem.
We're on the same page. All right.
Okay, so
And then if we could go, you quoted from this report, as I understand it, on the very last page, and this really is the fine print. You would agree that what you are quoting is this, starting at the second sentence, please note that all information shown is based on qualitative analysis. Is that where you found the disclaimer that you quoted in your rebuttal?
I think so, yeah.
Okay. And you would agree that that kind of disclaimer in the fine print would be in any kind of forecast for the future.
It could be, but it certainly is here. Be careful,
And
beware.
You also rely, as we discussed earlier, on analyst forecasts at various stages in your modeling. Isn't that right?
Yes, sir.
And for example, you use forecast yields on 30-year U.S. Treasury bonds as part of your determination for the expected risk-free rate.
Yes, sir, I did.
And would you be surprised that Blue Chip Economic Indicators says right on its reports, quote, Blue Chip Economic Indicators is a general circulation news monthly. No statement of this issue is to be construed as a recommendation to buy or sell securities or to provide investment advice.
I agree with that, but that's why I look at the CBO, the Congress Budget Office. I looked at the forecast from Bloomberg. I look at forecasts from the Energy Administration. I look at a whole variety of forecasts to make sure that we're all on the same page. They average about the same, 4%.
And you also rely on value lines, isn't that right?
Not for interest rate forecast.
Not for interest rate forecast, but for other parts of your analysis.
Yes, for growth forecast in the DCF model, I do rely on value line and on analyst forecast consensus.
And if we could turn to tab 32, which is from Value Line's website. And I would ask that this be marked NCJC et al. Cross-examination more in direct rebuttal exhibit 7.
All right, the document will be marked as NCJC et al. Cross-examination, more in direct rebuttal, exhibit number 7.
And if we just turn to the second page, there's a heading, use of financial content is at user's own risk. Do you see that?
Yes.
And if we look at forward-looking statements on the next page, can you read that paragraph?
Which one?
The forward-looking statements.
Certain statements published on the websites on the content are forward-looking. Such forward-looking statements may use words such as anticipate, estimate, expect, project, and believe in connection with a discussion of potential future events or circumstances. These forward-looking statements are based on certain assumptions and reflect our current reasonable expectation. Forward-looking statements are subject to a number of risks that could cause actual results or events to differ materially from such statements. You should not rely on forward-looking statements. Value Line disclaims any intention or obligation to update or revise forward-looking statements.
So as I understood your rebuttal, this buyer beware, caveat emptor, if the commission were to take that seriously and say we can't consider analyst forecasts that have those sorts of disclaimers that you pointed out for JP Morgan Chase, then they couldn't take into account forward-looking analysis from Value Line either, could they?
Well, the problem, if they were to do that, would be they would contradict all the empirical evidence that I discuss in my testimony that suggests that investors do rely on analyst forecasts in making investment decisions.
Right, and just like they might rely on capital market assumptions as well.
They might.
All
That's why we use so many other models as well, not just the DCF.
All right, we're going to go back to your rebuttal. On page 75, lines 6 through 10, you testified that you were, quote, I think if I got the quote right, that you were astonished at a comment on page 18, lines 19 through 22 of witness Ellis's direct testimony.
Yes, I was.
And if you could, do you have Mr. Ellis's direct testimony as it was originally filed?
I don't have it with me.
Okay. If I may approach. Well, a little bit of a quandary. I have Mr. Ellis's corrected testimony, but I'll show you what I'm referring to.
Mr. Neal?
Yes.
What is it that you're referring to?
Well, in Dr. Morin's rebuttal, he pointed to this, what he referred to as a comment, which is a heading in Mr. Ellis's testimony. The heading that says rate of return on capital and cost of capital are not the same. Rate of return on capital is a financial performance metric, whereas cost of capital is the measure of economic cost described in the Hope case. And that was referred to, that passage was referred by you as a comment. And I was just going to point out that it's a caption, a subject heading, and that what follows is the substance of his testimony. And so the real question is, that's the setup. The question is, did you read the testimony that followed, pages 17 through 23 of the corrected, 18 through 23 of the originally filed?
Yes, I read the whole testimony. I still remain astonished.
Yes. And
somebody that claims that return and cost of capital are two different things.
Well, do you recall the discussion that we had at the outset of this cross where we were talking about different terms and what they mean? Allowed return on equity. Return on equity is an accounting measure. Cost of equity in terms of investors' expectations. Do you recall those questions?
Yes, I do. Matter of fact, it's quoted right in my rebuttal on page 75 in italics. And I quote, cost of capital is synonymous with return. It's two sides of the same coin. What is the return required by investor? Turn it around, becomes the cost of the utility. They're the same thing.
Yes, but you recognize that there are, as we discussed at the outset, that they have different meanings when you're talking about return as an accounting metric and when you're talking about cost of equity that investors expect.
Yeah, I'm talking about market returns.
Yes,
which is the nitty gritty here. Cost of capital is the same thing as return. There's two sides of the same coin. What is a requirement by an investor becomes a cost to the company using their capital. Like a plumber, he wants $25 an hour required return. The cost of the plumber is $25 an hour. Same thing.
Right. In your rebuttal on page 74, you also describe some examples that you characterize as inconsistencies in Mr. Ellis's testimony. If we turn, well, I'm gonna move on from that. I apologize. All right, we're going to switch gears and talk about the multi-stage DCF model. And in your rebuttal at page 35, you referred to the multi-stage DCF model as misspecified.
Yes.
And later you say I believe on that same page, you're not aware of any financial literature supporting the notion that investment community looks to GDP growth over the next several decades when evaluating utility investments?
I'm not aware of investors looking at forecasts 20, 30 years from now when making investment decisions. They rely on it, analysts' forecasts shorter term, and the empirical evidence substantiates that.
Right. And if we turn back to new regulatory finance, Exhibit 1, at tab 76.
I have it.
And if we go to page 308.
What PDF page are we on?
What's that? 24.
I'm on page 24.
So page 308 is, they were asking about the PDF page. So it's of your textbook, it's page 308.
Show me the.
It's the heading is 9.6 growth in the non-constant DCF model.
It'll probably be towards the back.
Yeah, I got it. Sorry.
Yes. And do you see the last sentence of the first full paragraph under that section 9.6, starting with "it is useful"?
Yeah. It's useful to remember that eventually all company growth rates, especially utility service growth rates, converge to a level consistent with the growth rate of the aggregate economy. That's I agree with that, of course, I said it.
And page 82 of your rebuttal, you testify that you didn't rely on Value Line's prospective dividend yield estimate in your application of the DCF model.
Page?
Page 82 of your rebuttal.
I think I used the Zacks dividend divided by stock price.
And
this was the DCF model, the plain vanilla, the model that everybody uses, not the multiple stage model.
That's right.
Okay.
So I think this will be relatively quick. Again, you testified that you used dividend yields reported in the Value Line investment analyzer software.
Yes, in the original direct, yes.
Yes, and then and so that follows through to the original direct RAM Exhibit 4, that the source of dividend yields were from Value Line.
Correct. And
you would agree that Value Line, when it reports dividend yields, reports year ahead yields.
Yes, I would. That's why I used the Zacks current dividend yield and grossed it up by 1 year growth.
But in your direct, you said that you used Value Line and also grossed them up. Isn't that right?
That's correct, because that also accounts for the quarterly nature of dividend payments.
And in your supplemental testimony, you, as you've said, switched to Zacks. You didn't explain why you switched from Value Line to Zacks in your supplemental testimony, did you?
To avoid your question, basically.
So you would agree you didn't explain why you switched it?
No, I didn't explain it. I thought you'd understand it. I just used current dividend divided by stock price, then grossed it up. That way there's no confusion. The numbers are same, I mean.
And in your direct testimony on page 34, you testified that for the risk-free rate in your CAPM analysis, you used a 3.7% And that was based on yield forecasts and normalized yields on long-term U.S. Treasury bonds.
That is correct.
And then if we turn the page to 35, do you see at lines 4 to 5, there's a question. How did you arrive at your risk-free rate estimate of 3.4% in your CAPM and risk premium analysis? Does that indicate that you at one point thought 3.4% was the risk-free rate for your analysis?
No. Let me direct you to the bottom line here. Page 43. So what I did is I used the normalization technique, which gave rise to about 3.3% normalized interest rate. And I also used the economic forecast and I averaged the two. That's on page 43, lines 1 to 6.
I follow you. My question is a little different. If we go back to where we were just a minute ago on page 35, you're asked, how did you arrive at a risk-free estimate of 3.4% in your CAPM and risk premium? And my question is that 3.4% a mistake, or does that mean you previously thought it was 3.4 instead of 3.7?
That should be 3.7.
Okay. And in your supplemental testimony, that changed to 4.3%.
Yeah.
Isn't that right?
Yeah, in the more updated current testimony, we don't need to normalize interest rates anymore. COVID is over, et cetera, et cetera. So I simply relied on a whole bunch of economic forecasts of the yield on treasury bonds, and they average about 4.4. Right now, they've fortunately come a little bit lower, but
how much lower?
20 basis points.
So 4.1%?
Yes.
Are you going to?
If I was doing it today, I'd use 4.1.
Now, switching to value line as a source of your beta, you, in your rebuttal testimony again on page 83, you point to a 1984 article by Diana Harrington, the article called "Whose Beta is Best." Do you recall that?
Yes.
And you wrote, after describing that article on lines 12 to 14, that you have, quote, not come across any empirical research work that shows that value line betas are inferior to other beta providers. Is that right?
I don't know of any.
Okay. Well, let's turn to tab 46. And I'd ask that the document, which is at tab 46, be marked as NCJC et al. Cross-examination Morin direct rebuttal, exhibit 8.
All right, the document will be so marked.
And you would agree, Dr. Morin, this is the article we were just referring to.
Yes.
And if we look at in the journal, it's page 68, which I think is the second page of the article. You see there's a highlighted, I hope it's highlighted. Anyway, there's a phrase there in her article. Unfortunately, there is no single best method of estimating beta.
I agree with that, but the one that leads to the least measurement error is the value line.
Okay, then let's turn to page 70 of her article. And I'd point you to the last full paragraph of, in the far right column, the results for the utility sample. Actually, go back one. Before you do that, can you read do you see where she says, typically the beta forecast for the utility sample overestimated the actual betas? And then could you read that next full paragraph, the results?
Yeah, because the betas of this sample are generally small, this result suggests inefficiency in the beta forecast. An inefficient forecast will result in positive errors of low betas and negative errors of high betas.
I'm sorry, I wasn't clear. I appreciate that, but could you read the next full paragraph?
One in yellow?
Yes.
The results of the utility sample suggest several conclusions. First, sizable errors can be made.
If, for instance, your horizon was 3 years, and you were using value line betas to forecast the data for an average utility over this period, the average error you could have made would have been 0.28. Since the mean beta forecast value line was only 0.72, the error potential was sizable. Second, for the utilities, almost every method studied overestimated the actual data. And third, when the direction as well as the magnitude of the error is taken into account, mean difference, the OLS forecast was better than the value line forecast of the utility sample.
All right, and the other reason you give in your testimony,
Mr. Neal, is that the end of your questions on that exhibit?
yes.
All right, then we'll take a break now. We will come back on at 3:30. We're in recess. All right, before we return back to you, Mr. Neal, like to ask if there are any objections by any of the parties to commissioners reading the transcript in lieu of being in the hearing room during the course of this proceeding and ultimately participating in final decisions made in this case. If there are objections to that, please let them be known now. All right, heard no objections. All right, we will move on, Mr. Neal.
In my last
Thank you.
response to the question,
I believe we had finished with the response to that question and I was moving to it. You had asked, the chair had asked if we were done with that exhibit and I had said yes and was moving to another question.
Chair Mitchell, to the extent the witness has something to add to an answer given, I think the witness is entitled to
All right,
add
let's
to
do
an answer
this.
given.
You may add to your answer and you may ask again or continue on with your questions if necessary. And if we need to go back to that exhibit, you'll have to remind me, Mr. Neal, which exhibit we were on.
it's cross exhibit 46.
Cross exhibit number 8.
Okay. And I think the council had me read a yellow passage in that exhibit on page 70. And I just kept going on the next page on table 5. And the table shows the mean square error. That means how wrong the forecasts were for the utilities. And for a 1-year horizon, the winner is value line. For the 2 years horizon, the winner is value line. For the 3 years horizon, value line is the winner. 4 years betas, the value line is the winner. In other words, value line betas are not perfect, but they produce the smallest forecasting errors. That's what this table says.
The table speaks for itself, but you read the passage from the author who said that the results for the utility sample suggest several conclusions. Sizable errors can be made. And then referring to value line betas, the average error would have been 0.28. Since the mean beta forecast for value line was only 0.7241, the error potential was sizable. So you recall that,
I do recall it. The table says the smallest error are made by value line betas. Look at table 5. It's plain. They're the winners on 1 year, 2 years, 3 years, 4-year beta estimates. I'm not saying that value line betas are perfect, but they lead to the smallest error in forecast.
And she concluded, when the direction as well as the magnitude of the error is taken into account, that the OLS forecast was better than the value line forecast for the utility sample. That was her conclusion.
Right, but mine is based on real data that I see on table 5. Smallest error. So
you don't think the direction of error is relevant?
No, it can go either way. You can go overestimate or underestimate.
But if one source, for example, consistently overestimates year after year, that's a relevant consideration, is it not?
It would be, yes.
All right, let's go to tab. Well, first, before I go to tab 64, you testified that another reason that you use value line for your betas, and this is on page 22 of your rebuttal, is that value line makes use of the Bloom adjustment. Is that right?
Correct.
And the Bloom adjustment is based on the theory that betas converge towards the mean of all betas or to 1. Is that right?
That is correct.
So let's turn to tab 64. And I would ask that this be marked NCJC et al. Cross-examination, more indirect rebuttal, exhibit 9.
Document will be so marked.
Dr. Moore, I'm turning your attention to cross exhibit 9, the public utility beta adjustment in biased cost of capital in public utility proceedings by Professors Richard, Michelle Felder, and Theodosu. If we go to page 63 of that article, which I think is the 4th PDF page, I think. Under Roman numeral 3, they describe the data and analysis that they followed. That you will see that they reviewed monthly returns for 57 publicly traded U.S. public utilities from 1962 to 2007 and calculated the historical betas for those stocks using 60, 84, 96, and 108 monthly returns over 5 different non-overlapping periods.
Yes, I see it.
Okay. Now, would you be surprised at their findings that the betas in this study did not move towards 1, but in fact tended to decline over time?
No, I'm not surprised because we're talking about betas way, way, way back, 2013 and prior to that. We have seen on the graphs in my direct testimonies, the betas have been climbing steadily. So there is a tendency to go towards 1. And in plain English, what this really means, the Bloom adjustment, is that companies are like human beings. They mature over time. Throughout their dividend policy, their investment policy, their financing policy. And we see that in the graphs, that the betas of utilities are now 0.9, almost 1. So
for the period of this study, you see that the authors found that betas range from 0.08 to 0.59.
That's correct, yes.
And if you look at their conclusion on page 66, under that last column on page 66, above that big W, where they conclude, our results suggest that the Bloom adjustment is inappropriate for public utilities as it assumes that public utility betas are moving toward 1 in the long run, as are non-utility company betas. So you disagree with that conclusion, but this is the conclusion that these professors came to from their study.
Yeah, this is betas from 10 years ago. They have converged towards 1. They're 0.90 right now.
With the Bloom adjustment.
Yes. And it stands to reason that the risks of utility stocks have increased dramatically in the last 5 years or so. It's not surprising.
You also, on page 79, lines 19 through 20 of your rebuttal, state there's no theoretical or empirical justification for the use of geometric mean rates of return in estimating the cost of capital. Do you recall that testimony?
Yes.
And are you familiar with the work of Professor Aswath Damodaran at the Stern School of Business at NYU?
Very much so.
You're familiar with his informal title of the Dean of Valuation?
It's kind of a self-ego aggrandizing, but yes.
Have you ever seen his equity risk premiums that are regularly updated, titled Equity Risk Premiums, Determinants, Estimation, and Implications?
Yes, I have.
All right, turning to tab 66. And we would ask, we're up to number 10. So NCJC et al., cross-examination, more indirect rebuttal, exhibit 10.
Will be marked as NCJC et al., cross-examination, more indirect rebuttal, exhibit number 10.
And this is an excerpt from the document we were just talking about. If we move to page 36, and again, I don't know the PDF page. Probably 6.
Yeah, I have it.
Or 12, because it's, yeah. It would be under averaging approach.
Yeah, I have it.
Can you read what Professor Damodaran concluded under averaging approach?
The
Mr.
final-
Neal, before,
Yes.
I'm sorry, Dr. Moran, to interrupt you. I just want to make sure I'm clear here. This looks like excerpts to me. Is that right? This
That is
the
correct.
title?
Excerpts from Demoteran's
Okay,
report.
all right. So we are on page 35,
Page 36
36. Okay.
of the pagination. Yeah.
And I read as follows. The final sticking point when it comes to estimating historical premiums relates to how the average return on stocks, treasury bonds, and bills are computed. The arithmetic average return measures the simple mean of the series of annual returns, whereas the geometric average looks at the compounded return. Many estimation services and academics argue for the arithmetic average as the best estimate of the equity risk premium. In fact, if annual returns are uncorrelated over time, and our objective was to estimate the risk premium for the next year, the arithmetic average is the best and most unbiased estimate of the premium. There are, however, strong arguments that can be made for the use of the geometric average. First, empirical studies seem to indicate that return on stocks are negatively correlated over time. Consequently, the arithmetic average is likely to overstate the premium. Second, while asset pricing models may be single period models, the use of these models to get expected returns over long periods, such as 5 to 10 years, suggests that the estimation period may be much longer than a year. In this context, the argument for a geometric average becomes stronger.
And then just to the last highlighted concluding sentence.
In corporate finance and valuation, at least, the argument for using geometric average premiums as estimates is strong.
Now, recognizing, Dr. Moore, that you don't necessarily agree with Professor Demoteran, that you are at least now aware of a theoretical or empirical justification for the use of geometric means.
Yeah, there's a caveat in there. If you look at year by year historical returns, and I'm reading your yellow highlight. If annual returns are uncorrelated over time, arithmetic average is okay. So what I've done in my research is I've looked at the average returns year by year, and it's a random walk. There's absolutely no history in the time series of market returns. They are uncorrelated over time. The correlation is 0, and that justifies the arithmetic means. And all the other authors that I know, Greeley and Myers in their textbook, Brigham, Ross and Westerfield, all these textbooks strongly suggest that for estimating the cost of capital, arithmetic means is the way to go, because these are single period models. The geometric mean return is okay as a summary of past performance. You know, from 10 years ago until today, my portfolio averaged 7%, let's say. The problem is it doesn't tell you about the obstacles along the way, about the risks, about the variability along the way to get from A to B. The arithmetic mean does. I would direct you to an appendix in my testimony, which strongly suggests.
Again, recognizing you don't agree.
Yeah, but
as
I'm
I
telling
said.
you why.
And but Professor Demoteran gives some information, some explanation for why geometric means over a longer time period, that there is a theoretical and empirical justification for using them, whether
Yes.
you agree or not.
Yeah, I don't, and nobody else seems to either.
In your rebuttal on page 86, you say there is nothing proprietary about the empirical kappa model.
No, I don't have a monopoly in that model.
I understand that, not suggesting a trademark necessarily, but if we go to tab 80, which we will ask to be marked NCJC et al. Cross-examination, more indirect rebuttal, exhibit 11.
The document will be so marked.
These are excerpts from, I believe, your 2021 book, Modern Regulatory Finance. And feel free to refer to it if the book, if you prefer. But if we turn to page 220 of that excerpt, 7.3.
Yes.
PDF page 5. Again, page 220 of the text. 7.3, the caption reads empirical, parentheses, Morin, Kaplan. Do you agree?
Yes, I'm the one that popularized it and tested it empirically and led to its wide usage.
And that's
The reason I called it the Morin model is because the New York Public Service Commission uses the empirical CAPM and they call it the Morin CAPM.
all right. You would agree, moving to another topic, that the commission is not required to rely on any particular model when making its decision to set the allowed ROE. Isn't that right?
I agree with that, but I would caution the commission to rely on all the evidence, not just single out DCF or CAPM. All the evidence is relevant. We're trying to figure out what's in the minds of investors here. We need all the help we can get. So we use the DCF, we use the CAPM, we use the risk premium. We're trying to triangulate between the three. We use all the evidence that is available. And I always use the analogy of a pilot flying on one instrument. That's a pretty dangerous flight. You should rely on all the instruments. Same with a finance expert who relies on all the models.
And it's the commission that's ultimately going to decide the cost of capital, which cost of capital studies to consider and estimating the cost of capital in this proceeding.
I agree with that. It's their prerogative.
And the commission is going to be tasked with independently assessing the reasonableness of the inputs selected. Isn't that right?
That's correct.
And the assumptions that were made.
I agree with that. And the judgment that was involved.
And
who do you trust? Whose judgment?
And turning to tab 42.
I have it.
All right. We would ask that the data request response at tab 42 be marked NCJC et al. Cross-examination, more indirect rebuttal, exhibit 12.
All right, the document will be so marked.
And you see that this is the company's response to a data request that we submitted, number 16-1. Correct?
Yes, it's my response.
Okay, great. And we were asking for any evidence that supports the claim that you made in your direct testimony that low allowed ROEs can increase the future cost of capital and ratepayer costs. Do you recall that question?
Yes, absolutely.
Okay. And then the example you gave was from Arizona, a company called Arizona Public Service, and a decision from November 9th, 2021. Do you recall that example?
Vividly.
Yeah. And if we now go to tab 38, we have, we'll ask that the exhibit there be identified as NCJC et al. Cross-examination, more indirect rebuttal, exhibit 13.
All right, the document will be so marked.
And this is an excerpt from that opinion that we just talked about. Do you agree?
Whose opinion?
The Arizona Corporation Commission.
Okay. I have it.
Okay. So if we move through the table of contents, cover page, to give it some context, and we get down to page 329 of the opinion itself, which is the very last, second to last page of the exhibit from a double-sided perspective.
I have it.
So and again, as you brought up in your response in cross exhibit 12, the commission decided a allowed return on equity of 8.7%. Is that right?
Yes.
And I believe in your discovery response, you indicated that it had been 10% before this decision.
Correct.
And you see, if we're looking at the middle line, it's sort of at the 8.7% is applied to common equity of $4.7 billion.
Correct.
And you would agree that the difference between 10% and 8.7% is 130 basis points.
Yes.
And not asking you to do the math in your head, but 1.3% of $4.7 billion is a substantial reduction in the revenue requirement. Would you agree it's about $61 million?
As a matter of pure arithmetic, yes.
And you would agree.
Sorry. Can I finish?
Sure.
But what about the consequences? The data, the order came out, the bonds were assassinated. The market value went down, both the stock and the bonds. Moody's, Fitch, S&P immediately put a negative outlook on the bonds with a potential downgrade. It was a disaster. And that means that the cost of money is now going to go up for ratepayers in the future. All right. And that means that it's not beneficial to ratepayers if the cost of borrowing these millions of dollars in the future has gone up because of this order.
And you would agree that that $61 million figure would be grossed up for taxes. So in terms of the actual effect, it's actually even more than $61 million because it has to be grossed up to account for income taxes.
That's just an arithmetic conclusion.
Yes.
The bottom line, real world conclusion is they're going to cost a lot more money to raise capital in the future.
I've heard you.
I'm in the case now where they're still trying to pick up the pieces from that case. And I think there's willingness to repair the damage that was done.
Well, not speculating on what the Arizona Corporation Commission would do. Would you think 25% is a reasonable estimate for how much that would be grossed up for taxes?
No, I don't agree with that at all. It's got nothing to do with what I'm saying here.
No, I'm sorry.
If you give a return of 8.7% and the average return for vertically electrics is 9.7, who on earth is going to invest in that company? Nobody, unless the cost is way, way up, in which case the revenue requirements will go up. So you have to go through the whole dynamics of the thing, not just the static arithmetic statement you want me to make.
I'm asking you a question whether or not the return on equity figure is grossed up to account for income taxes.
It is, typically, whatever it may be. Even if it was 10%, it'd be grossed up, or 6% would be grossed up. That's arithmetic.
So let's assume for purposes of this discussion that $61 million that went out of rate base, that ratepayers didn't have to pay in this instance, is grossed up by 25%. That would be $76 million. In just looking at this in isolation, recognizing that you don't agree about looking at it in isolation.
Yeah, that's, again, pure arithmetic,
right.
Yes.
And according to your response again, going back to cross exhibit 12, you didn't provide anything in that response about concrete costs that ratepayers have incurred to date of Arizona Public Service as a result of that decision. Again, I understand you're talking about what might happen, but no upward costs have yet been imposed as a result of that decision.
If a regulatory decision, as disastrous as this one was, leads to an increase in the cost of debt and the cost of equity, that will be very detrimental both to the company and to ratepayers because it will produce much higher revenue requirements in the future. That's real. Now, if you get downgraded from, let's say, single A to triple B,
it's going to cost you an extra 50 basis points. That's half a percentage. And if a company is going to borrow hundreds of millions of dollars in the next 5 years at a 50 basis points higher cost, that's huge impact on ratepayers. That's what I'm talking about.
What evidence do you have in the record, Dr. Morin, well, first, I'm going to take a step back. The downgrade that you indicated in your discovery response at Exhibit 12 is that the downgrade was from A- to BBB+.
Right.
You would agree that's just one notch
Yeah, that's
downgrade.
probably 25 basis points higher cost.
You don't have any evidence in the record to show that that's a 25 basis point cost.
Yes, I do have evidence. All you have to do is look at the spread between A- bonds and B+ bonds. It's about 25 basis points.
Well, again, A- to BBB+.
Yes.
About
25 basis points.
Maybe 20, maybe 25.
That's a lot of money.
We're going to get to that. We're going to get to that.
A lot of money.
So, last I looked at the difference in borrowing costs from a downgrade of A- to BBB+, it was 0.1%. I appreciate that you think it's 0.2 or 0.25%. But for purposes of the question, assuming that the cost of debt went up 0.1% and APS had to reprice all of their debt of $3.9 billion, the incremental cost to ratepayers is 0.1% of that $3.9 billion.
Duke
Correct?
Energy is going to raise, let's say, $5 billion next 5 years. Half of that is going to be from debt. That's $2.5 billion. Do the math times 10 basis points extra. That translates into tens of millions of dollars of additional cost to ratepayers, let alone the cost of equity impact.
Well, again, staying with me here, if it's a 0.1% incremental difference in the cost of debt, that's $3.9 million on a $3.9 billion debt. And of course, they don't have to refinance all of their debt. Those are contractual agreements. They just it'll affect their borrowing costs going forward. Isn't that correct?
Absolutely. And the ratepayers will be damaged.
But $3.9 million is much less than $76 million as a matter of basic arithmetic.
Yeah, but you're not taking into account the repercussions on the cost of equity either. Just the debt cost, and 10 basis points is not correct.
Well, the costs of equity are decided by investors, and it has an effect, as you said, on stock price.
It sure has. The stock price went down 26% after that order.
And we discussed at the outset how you don't subscribe to considering market to book ratios, but you would agree that the utility stocks in your proxy group are at about a 2-to-1 market to book ratio. Isn't that right?
Utility stocks have been trading at market to book ratios well in excess of 1 for almost 40 years.
And
got to keep up with the industrial. Want to attract capital.
But this was the example that you provided when we asked for a concrete example of how a low allowed ROE would impose additional ratepayer costs.
I just don't want this commission to go there, anywhere near there, okay? Just based on the Arizona disaster. This commission is rated above average for a reason. They won't do that.
I have no further questions.
All right. Public staff, you're up.
Dr. Morin?
Hi.
My name is Will Freeman. I'm an attorney with the public staff.
Okay, nice to meet you.
It's nice to meet you too.
Okay, well, we'll see ya.
No.
Is this your book?
That is my book, but I promise not to use much of it. I would like to have a conversation with you and this commission about an appropriate return on equity. And I think that we can agree that regulation is a surrogate for competition, that this commission acts as a substitute for the marketplace.
I agree.
And we can agree that, and I think we went over this with Mr. Neal, that we're trying to hit that equilibrium point where the rate of return is equal to the cost of capital.
I agree. Well said.
Oh, thank you. If we go, let me be real specific with my language. If the rate of return is greater than the cost of capital, there's a transfer of wealth to the shareholders from the ratepayers.
Correct.
On the flip side, if the rate of return is less than the cost of capital, we've got a transfer of wealth from the shareholders to the ratepayers.
Correct.
We don't want transfers of wealth.
Correct.
Okay. When we're having this discussion about return on equity, there's not a single correct answer. There's a sphere of correct answers. Is that a fair statement?
There's a range of estimates from the various models.
I like range better, a range of estimates. And so we can't just sit here and say it is 9.17632. We've got to kind of discern that range. And that's part of the process that we're going through today.
I agree with you that there's no answer to 3 decimal points. It's a range.
It'd be easier if it was. And what we're going to do is use our informed judgment, or the commission's informed judgment, informed by the evidence that we put forth, to get to that range, and then within that range, select a number.
I agree with that.
Okay. So I'd like to talk about some data that I think should inform the commission's judgment. And if you would turn with me in the big book to public staff's proposed cross exhibit number 18, page 6 of 22.
Page
6 of 22.
I have it.
And if you'll see the answer to question 25, we've asked, what is the value of a single basis point? And I think the response is,
Mr. Freeman, we need to mark the document.
thank you so much. Commissioner Chair, I propose to mark this as public staff, cross-examination, Moran direct and rebuttal, exhibit 1.
All right, document will be so marked.
Dr. Moran, I don't mean to rush you. I just wanted, you're free to look at the whole page, so I put it in here for completeness, but page 6 says a basis point adjustment would have approximately a $1 million impact on the consolidated revenue requirement.
Based on the assumptions that you made on revenue requirements and all of that, which are probably incorrect because of the settlement figures are quite different.
It's going to be different because of the settlement figures. But this is the data request I received from Duke. So well, first, it doesn't surprise you that a utility this size, a basis point of 1 basis point is worth about $1 million.
Not at all.
So when we're planning, we have a 3-year, planning is the wrong term. We have a 3-year, multi-year plan here. So it'd be $1 million each year, right?
Or less.
Or less or more, depending on the settlement, right? And I calculated some exact numbers on the first page, but I think given the settlement that I don't want to use specific numbers. I want to just go with about $3 million over the whole multi-year period. Is that a fair characterization?
I'll take a subject to check. That's
Okay.
not something I considered in my testimony whatsoever.
I totally understand. Subject to check. So let's sort of start at the beginning. And I think this story starts on June 1st of 2021, when this commission entered an order that Duke Energy Progress should have a 9.6 return on equity. And 52.
I think the date was actually April 16th.
I believe the order was signed April 16th and the rates became effective June 1st.
That would make sense.
So let's just say 2 years ago-ish. 2 years ago, 9.6 return on equity was appropriate for Duke Energy Duke Energy Progress. And that was an agreed upon settlement. Do you know?
Yes, it was.
Oh, okay.
That's 2 years ago. Yeah.
I totally understand. So if you'll turn with me to, I'd like to see what happened in that first year after the 9.6 ROE was allowed. And
Well, interest rates went up, inflation went up, the risks went up. That's what happened.
so bad news for DEP, correct?
Yes, bad news for everybody.
Okay, but bad news for DEP 2. So let's turn with me to the tab 27, which I would propose to mark while you turn as public staff cross-examination, Morin direct and rebuttal exhibit 2.
All right, Mr. Freeman, just making sure we are looking at the same document. It's potential cross exhibit number 27, as you said, but it's a letter dated August 31st, 2022.
Correct.
Okay.
It consists of 6 pages.
Okay.
And if you'll look with me at page 2 of 6, there's some shading on your page, I believe.
Yeah.
So now you see now, this is from June 30th, 2022, so 1 full calendar year after those June 1st rates are effective, and a little bit more.
Yeah, I see it.
And we have a return of 11.39%.
Chair Mitchell? I think unless the witness knows what this document is, it's more appropriate to be used on a company witness who might actually know what this document is. I won't object to it, but I believe since the company prepared the document and not Dr. Morin, and Dr. Morin didn't rely on it in the course of coming to his opinions, it's a more appropriate question to be asked of a company witness.
Yeah, I'd love to be cooperative and.
Let me, Dr. Moore, let me hear a response from Mr. Freeman.
We just discussed how that was terrible times happened in that year, and I wanted to compare the allowed return versus the actual return.
All right.
But that's the problem. There's a lack of foundation to actual return with respect to that particular question, and I would object to that particular question.
2 points. First, this is drawn from a publicly filed document, so I don't know that there's foundation issues. The entire documents are found in that folder, but we just put in the excerpts. To the extent you have issues, I put in the cover letter because you note those issues here. That's why they're part of this excerpt. I think it's part of the entire picture. I guess maybe I can phrase the question and just say, we've got an allowed ROE of 9.6%, and we're coming in over that a year later. Is that what that document tells you?
Object to the formula to the question because it lacks foundation.
All right, I'm going to overrule the objection. I'm going to let Dr. Morin answer that question and answer it to the best of your abilities, given what you know at this moment on the stand.
Well, I apologize. I don't have a response to this, and I had absolutely nothing to do with this exhibit or numbers or what you're trying to convey. I know it was 9.6% in 2021, and interest rates are up and inflation's up, and today, as we speak, it's higher than that. And that's my testimony, the cost capital today.
Okay.
I'm sorry, I wish I could be more cooperative.
No, yeah, I appreciate it. If you'll flip to page 6 of 6, that's the most recent filing, December 31st, 2022.
I'm sorry, what exhibit are we on?
I believe it's now been marked exhibit 2.
The same exhibit.
Same exhibit.
Same answer.
Okay. Does it trouble you or surprise you when a company earns more than its allowed return on equity?
A little bit. The more common result is utilities under-earn the allowed return. That's far more common. Both are surprising, and the forecast can be erroneous. Revenues or costs, they can go either way, and so it's not that surprising. It depends on the magnitude of the error.
Is 150 basis points, 200 basis points a magnitude?
Then that would start worrying me a little bit. That's quite a bit. If we're talking about the utility, not the parent company.
I understand. And this is DEP right here.
Yeah.
Okay, just to get back to, this is a hypothetical question. When we have a company earning more than the correct cost of capital, right? The company's higher. That's a transfer of wealth from the ratepayers to the shareholders.
I agree.
Okay, thank you. I'd like to ask about a different topic if you're ready to move on.
I'm ready.
Okay. So we're here today to prove, I guess DEP is here today to prove to this commission that the rates that went into effect less than 2 years ago are so unjust that they need to be altered. And so the conversation we need to have, and this is the question, I think we kind of have two conversations. One is, should they be adjusted? And two is, if they are to be adjusted, what is the correct rate? Is that a framework that we can think of together?
Not really. My
Okay.
contribution, my humble contribution to this proceeding should be the allowed rate of return today.
I understand. Okay, then
Period.
I will set aside that topic entirely and just focus on the allowed rate of return, if you don't mind. I'm going to say a little bit less. You don't have to be humble. You named the formula after yourself, doctor. You can say I'm the guy, and that's fine. I'll say it for you so you can be modest. In October 6, 2022, you filed testimony in this case that the appropriate return on equity was 10.2%.
Right.
And then in February 13th, 2023, supplemental testimony, now it's gone up to 10.4%.
Because the interest rate forecast went up. Yes.
Okay. And in fact, I'll give you just one more data point. You filed on December 15th, 2022 in South Carolina that 10.4% was appropriate.
Correct.
So from October to December, 2 months, we have a 20 basis point increase because
Interest rates have gone up, or forecast interest rates have gone up.
okay.
And sure enough, what I use as a forecast actually turns out to be correct today.
Blue chip is one of the things you use?
One of the things.
Okay. Would you agree with me that interest rates have started to come down?
I agree that they have tapered off a little bit.
All right, that's good news.
That's very good news. That's why I lowered my ROE.
Is your ROE lower?
Well, if I was doing it today, it'd be 10.2 instead of 10.4.
Okay, I understand.
Because you're right, the interest rates have hit a ceiling and they've started to either remain constant or slightly come down to the 3.9, 3.95, 4% range, which is a good thing.
I agree. I'd like to move on to a slightly different topic, if you don't mind, and talk about some things that I think might have value to inform the commission's enlightened judgment. Your testimony would have value for the commission.
Oh, geez, thank you.
I think what DEP thinks its own return on equity would have value to the commission. Do you agree?
Yes, it'd be interesting. I would like to know that too.
Yeah, let's take a little hint into DEP's minds. If you'll turn with me to tab 7, which I would propose to mark as public staff cross-examination, Moran, direct and rebuttal, exhibit 3.
Document will be marked as public staff cross-examination, more indirect rebuttal, exhibit number 3.
Tab 7, Doctor.
Yeah, I have it. Oh, tab 7.
I apologize, tab 7.
I have it.
This is a publicly filed document. It's an excerpt from a much larger document in South Carolina. It's a comprehensive settlement agreement. And if you'll look on the first page and on the right-hand column, filed January 12th of this year.
Yes.
And if you look on page 3 of 5, the parties to this case, you see some shading, I think, on your copy?
Yes, I do.
I'm going to paraphrase. The parties to this case agree a fair and reasonable settlement for the return on common equity is 9.6%.
Yes, I agree. It's there.
Okay. And it's actually, if you look on the next page, page 4 of 5, parties agree the settlement is reasonable in the public interest and in accordance with the law.
I can read.
And the final page of the exhibit, this is an actual signature from Mr. Progress, from Duke Energy Progress. So This is some insight into what DEP thinks in, at least as of January 12th in South Carolina, what DEP thinks was a reasonable, and I want to use the exact one, reasonable, fair return.
You're well aware, and more than anybody else, as a party to this settlement, that there's a lot of give and take and a lot of variations and assumptions, and we'll give you this and we take that, and there's a lot of that going on in the settlement. So
I understand. If you'll turn one tab forward to tab 8, a document I propose to mark as public staff cross-examination, pardon me, public staff cross-examination, Morin, direct and rebuttal, exhibit 4. This is an excerpt from that same case.
And that document will be so marked.
Oh, I apologize, Commissioner. Excerpt from the same case. This is an order for the actual commission 2 months ago, a little bit less than. And if you'll turn with me, the South Carolina Commission found 9.6% return on equity would result in just and reasonable rates. That's another data point for this commission to consider. Is that fair?
yeah, same answer to previous quote.
Absolutely. Now, of course, this commission is much better than any other ones, but that is a data point for them to consider. I would like to discuss, just let me note before we move on from South Carolina, there is no decoupling in South Carolina. There is no multi-year rate plan. This is a plain old-fashioned rate case. Is that right?
I believe so.
Thank you. The additional data point is what other commissions across the whole country are doing. And so, and again, I'm not trying to bind our commission to other countries. We have different laws, other states. We have different laws, different facts. I totally concede that point. But if you'll look with me at tab 9, which I would propose to mark, public staff cross-examination, Morin, direct and rebuttal, exhibit 5.
Document will be so marked.
This is a document taken from RRA.
I'm very familiar with it.
I think that we need to look, apples to apples. We want to look at page 2 of 2 of this document where I see vertically integrated electric utilities.
Yes, I see it, 9.69%. Yeah.
Okay, and just the last, I'm going to read off the last few years and you tell me if I've got it right. Let's see, 2022, and this data runs, you see it's compiled this year, so it's got all of 2022 and 9.69% this year, last year, year before, 9.53, 9.55, 9.74, and so on. We have to go all the way back to the early 2000s to get to 10.2 and 10.4.
And one more data point, as you call them, for the first quarter of 2023, it's 9.71%. And for the gas utilities, 9.75. So they are inching upwards with the rise in interest rates and inflation.
Okay. 9.71 though for vertically integrated electric utilities.
Yes,
this
sir.
data went through March 31st or so.
This is only till 2022.
I was asking, if we go forward a little bit further, we get to 9.71.
No, correct.
For vertically integrated electric utilities.
Correct.
Thank you. RRA is, you cite it, it's a common industry source for information.
Very common, yes. It's a subsidiary of S&P Global Intelligence.
Okay, another data point I'd like to look at with you is what other analysts think. And if you'll turn with me to the tab 26, which I would propose to mark as public staff cross-examination, Morin, direct and rebuttal, exhibit 6.
All right, we're looking at RBC Capital Markets. briefing?
Yes, Commissioner.
Okay, all right, document will be so marked.
When you're ready, Dr. Moore, I'm not
I'm
trying
ready.
to rush you.
I'm ready.
I didn't look at the last page to see if it had all the caveats that you were talking about with Mr. Neal, but I'd like to look at just the first page. January 15th, 2023. And you'll see 3/4 of the way down the page, there's a paragraph that starts with "on Thursday." Do you see where I am?
So I have another Moody's that I'm looking at here.
Oh, I apologize. We're behind tab 26, RBC Capital Markets.
Sorry.
I can hand you my copy if.
No, I haven't. Got it.
Okay. First page, "on Thursday." And if you're ready, I don't want to rush you, Doctor.
I haven't.
Okay. I'm going to read with ellipses "on Thursday." So this would have been right after that South Carolina settlement we just talked about. Thursday, DEP announced a comprehensive agreement. Highlights include a rate increase of 52 million, 9.6 ROE, and 52.43 cap structure.
I have.
Okay. Relative to their ask, which was higher. And it says, now RBC, not me, our view, this settlement was largely positive for Duke and is in line with previous decisions by the commission. So can we agree that RBC Capital, let me stop, what a great name, Watts Cooking. But anyway, can we agree that RBC Capital in January said 9.6, that's in line?
That's opinion of Royal Bank of Canada. That's one opinion.
I understand. I would like to talk to you about some more opinions. I will try to make them not be Canadian. If you'll turn with me to Exhibit 23.
Don't forget, I'm originally from Canada.
Are you really?
I'd be careful.
We're gonna have some, we'll talk about that when we're not on the record, but if you'll turn with me to 23.
And I'm going to the hockey game tomorrow night with a hurricane. So.
Okay, we got a lot to talk about off the record. Good for you. Okay, 23, Morningstar report, which I would propose to mark as public staff cross-examination more in direct and rebuttal, Exhibit 7. And if you look at page 4 of 43.
Document will be so marked.
Oh, Morningstar 4 of 43.
I have it.
Now I've lost my place. Yeah. And if you just look, if you'll just look on the 3 of 43 at the very bottom, this is a note from March 2nd of 2023. So 2 months and 2 days ago. And they're just discussing the second full paragraph. We expect management will seek recovery of the investments through rate case proceedings across Duke's jurisdictions. We don't expect a material change in company-wide average allowed returns. So
the key word being material.
Morningstar is telling us that they don't think it's going to be much higher or much lower than it has been, right? We think it's going to be on par with company-wide average returns.
Well, just keep reading. Regulatory risk remains the key uncertainty, particularly given Duke's aggressive investment plans for the next several years.
Absolutely. The whole document's an exhibit for you to tell the commission any part of it you'd like. I wanted to highlight for this commission the fact that Morningstar seems to think, and there are risks, upsides and downsides, but Morningstar seems to think we're going to be about where we were, and that's okay with them.
That's one opinion.
Okay, I grant that. Now, if you'd like, I'd like to turn to tab 24, which I propose to mark as public staff cross-examination more in direct and rebuttal, Exhibit 7.
All right, document will be marked as public staff cross-exam. I've got it. Public staff cross-examination more in direct rebuttal. Exhibit number 8.
Guggenheim. Are you there, Dr. Moore?
Yes, I am.
Okay. Guggenheim. Guggenheim Securities, LLC. You'll see this is dated February 10th, 2023. On the first page, page 1 of
23.
Thank you so much. Page 1 of 23. Again, Guggenheim here is reporting yesterday, the Public Service Commission of South Carolina voted to adopt the settlement filed in the Duke Energy Progress's rate case. See that first circle there?
I do.
And then let's skip down to the Guggenheim takeaway. The 9.6, the cap structure approved and the ROE approved. Guggenheim takeaway, a constructive outcome insofar as the joint settlement was adopted by the commission. This is the same settlement Guggenheim covered. Guggenheim states this, quote, "We continue to model about 9.6% ROEs at DEP, consistent with how this order turned out, and which reflects the combined GAAP financial reporting produced to encompass DEP's NC, North Carolina and South Carolina operations."
It is what it is.
Is this another data point that 9.6 in February is what Guggenheim thought was a fine ROE?
That's one person's opinion.
I agree. And I know you have a much different opinion, but I just want to go through some other opinions first. I'd like to sort of change topics entirely if you're still okay.
I'm okay.
Can we agree that DEP has the authority to consider how rate impacts will affect customers?
Yes.
And I think your testimony discusses North Carolina economic conditions.
Yes.
And DEP has the authority to reduce, if it wanted to, has the authority to reduce its ROE request in order to mitigate rate impacts to customers.
It could.
It could unilaterally do that without any, if it wanted to.
Yeah, at the risk of procuring capital in the future at a higher cost.
Absolutely. If you'll turn with me to tab 14, which I would propose to mark as public staff cross-examination, Morin, direct and rebuttal, exhibit 8.
All right, the document will be marked for identification as public staff cross-examination, more indirect rebuttal, exhibit number 9.
I'm sorry.
Yeah.
This is Mr. Newland's testimony filed December of 2022 in the rate case for DEP in South Carolina. If you would look with me at page 21 of 27, lines 10 to 12.
I have it.
We can see here that DEP in South Carolina in December dropped its ROE request. Well, let me not say dropped, declined to increase its ROE request and came down 20 basis points from your recommendation, quote, to mitigate any further rate impacts to DEP's South Carolina customers.
I could live with that number.
I understand. I haven't seen no filings that there's been a 20 basis point decrease in North Carolina for our ratepayers. Are you aware of any?
No, I mentioned earlier in your cross-examination that there's been a slight stabilization of interest rates, and if I was doing it today, it'd be probably 10.2.
Okay. I'd like to talk to you about an entirely different topic, which is flotation costs. If you're, well, what was the smile for?
His favorite topic.
Let's just big picture. You would agree with me that you think DEP DEP's return on equity percentage should be increased to compensate DEP for flotation costs.
Yes, absolutely.
20 basis points?
Yes.
So that's a increment, an increase in the ROE, correct?
Yes.
Okay. And flotation costs are the expenses of issuing equity, attorney's fees, underwriter fees, printing fees, all those sorts of fees. Is
Yeah,
that right?
if the company issues stock at $100 a share, it will only net $95. Okay. So in order to produce the same rate of return to investors based on $100, they have to earn a little bit more on the reduced equity base of $95. That's really the guts of the matter here.
Okay. If you would turn with me to Public Staffs, tab 5, which I would propose to mark Public Staff Cross-Examination Morin, Direct and Rebuttal, Exhibit number 10.
That document will be so marked.
This is a data request, a response by Duke to a data request. If you'll look with me at page 2 of 2 of the document behind the 5th tab.
Yes.
Just in particular, D and E, you'd agree with me that there aren't any flotation costs historically or in the near future.
They're none forecasted for the future. In the same way that even though you're not building new plants, you continue to recover past costs, even though you're not investing in new plants. You continue to depreciate the plants based on the past investment. Same thing for flotation costs. All that massive equity capital that's in the books right now, it was acquired at a flotation cost of around 5%. It's the same idea here.
So part of the reason that we think that you think flotation costs should be awarded here is because we have to compensate the shareholders for the flotation costs that were incurred in the last stock issuance, which was well before the test year.
That's correct.
Okay.
It's the only way to recover it.
I understand.
It's not expensed. It has to be recovered too, like depreciation.
And I just want to make sure we don't have any test year flotation costs and none forecast through 2027. Correct.
That's correct.
Okay. So if you would now turn with me to the document behind tab 3, which I would propose to mark as Public Staff Cross-Examination Morin, Direct and Rebuttal, Exhibit 11. I don't want to spend too much time on this.
All right, the document will be so marked.
Just very briefly, if you'll look with me at page 4 of 7. And I'd like to make 2 points with you on this. If you're on page 4 of 7.
Yeah, I have it.
First, this is the Supreme Court of North Carolina. See footnote 4 at the bottom there?
Yes.
They kind of have this interesting academic discussion about whether they should even be in ROE or instead should be expensed as costs. But they don't answer it for us. So you and I are left to discuss it further. What they do answer, which is in the body of the text I've highlighted, is they've said in the absence of evidence, it's unsupported to increase ROE.
What about the litany of references in Appendix B about the magnitude of flotation costs? There's a lot of empirical evidence, a lot, for utility stock offerings. On average, 5% flotation costs.
It's your appendix B to your
opinion,
testimony.
It's based on empirical evidence.
I'm sorry, when you said Appendix B, I just want to make sure I understand. It's the one that's appended to your direct testimony filed in this case.
Correct.
And for the reasons set forth in your Appendix B, you believe that flotation costs are appropriate.
Well, they are. Most textbooks in finance do the same thing.
I totally understand. Just one more data point and then we'll move off flotation. If you'll turn with me to tab 4, which I propose to mark. It's an excerpt. I propose to mark it Public Staff Cross-Examination Morin, Direct and Rebuttal, Exhibit 12. And I've highlighted just If you look at page 3 of 4.
Yeah, I see it.
Okay.
All right, the document will be so marked.
This is 2 decades ago, admittedly. But here we see the commission rejecting flotation costs because there was no evidence of actual costs.
I disagree. I mean, equity capital is not free. You do it for debt, you do it for preferred stock. You got to do it for equity too.
I understand. Okay. I did promise to move off flotation, so that, let's talk about the impact of this new law in North Carolina. And I heard, I think Witness Bowman said this morning that it was modernizing. I think that was her terminology, but correct me if I'm wrong. This law, and you can look at it if you'd like. I don't want to move statutes into evidence, but if you'd like to look at the law, it's behind tab 1. But if this law instructs this commission to, quote, consider any increased or decreased risk to either the electric public utility or its ratepayers that may result from having an approved multi-year rate plan. That's on page 5 of the document behind tab 1. So I would like for me and you to now take some time to consider what this new law does to risk as instructed by the legislature. DEP testified this morning it was modernizing, and I think that sort of tells us that they are in favor of this law. That's one data point, that they like it. Is that a fair statement, you think?
Yeah, I think streamlining would be another choice.
Certainly relative to North Carolina, the risk is down. And I agree. I want to talk about risk generally in a minute, but we didn't have this law and now we have it. Just in strict terms, now risk is decreased on the utilities relative to North Carolina only, relative to 2 years ago.
Again, in absolute standalone terms, it does reduce volatility and therefore risk. But that's already in the data that's viewed, embedded in the stock prices and data and all that. We've already accounted for that.
I totally understand. I'd like to talk a little bit more about that point right now.
Okay.
I think I'd like to start before we get into that is to start with what other people have said about this law. And so if you would turn with me to the public behind tab 15. And this is, I propose to mark this as public staff cross-examination, more in direct and rebuttal exhibit 13.
All right, the document will be so marked.
And I misspoke when I said I'd like to talk about what others say about this law. This is a document addressing in the state of Washington what happened when a multi-year rate plan was enacted. And there's some shading on page 1 of 11 and some shading on page 2 of 11. If you're ready, I'll discuss it just briefly.
I'm ready.
This says that these two entities, these two electric companies, their ratings improved as a result of this new law, quote, this rating was improved as a result of the Senate Bill 52995, which was signed into law in May 2021. The legislation allows for multi-year rate plans, reducing regulatory. Can we agree that as a result of a multi-year rate plan, in the views of Fitch, that their rating outlook went from negative to stable?
Mm-hmm. Well, you're sort of proving my own point. Okay. It's already embedded in the bond ratings. In the same way in the stock market, it's already into the stock price. So you don't want to double count. You're really proving my point. And the commission has ruled on this previously in the water case that you shouldn't adjust the ROE because it's already reflected in the data.
I'm glad to talk to you about the water case in just a minute, but I just want to focus on the specific thing.
Okay.
Here we have a concrete result. They went, first off, going from negative to stable. That's good. Correct?
Yes.
That's what I want if I'm an electric utility.
That's favorable.
Yeah. So a favorable thing occurred solely because this new law was signed.
Correct.
Okay. Now, if we can turn to Exhibit 19. Which I propose to mark public staff, cross-examination, Moran, direct and rebuttal, Exhibit 14.
All right, the document will be so marked.
And when you're ready, Doctor.
I'm ready.
Okay. This is a document from S&P. And it's, if you look with me under page 1, key strengths. Do you see where I am?
Yes.
The third sort of key strength. Recent passage of HB 951 legislation in North Carolina includes key aspects that we view as favorable for DEP's credit quality.
And I agree with that completely.
Okay.
But again, all the other companies that have had these risk mitigating mechanisms are also subject to the same opinion that it's a good thing because it's offsetting all these other new risks that have appeared on the horizon.
I want to talk to you about that sentiment in a moment, but let me stick on my topic right now. If you'd look behind the 23rd tab, we're back to that Morningstar, which I believe, which was previously identified by this commission. And if you'll look with me at the document behind tab 23 at page 1.
I have it.
That second paragraph. See where we are. The outlook has improved significantly. We view the legislation as a significant improvement in the regulatory constructiveness in the state.
Totally agree with that statement.
Okay, good. Let's move on then to the 20th, the document behind the 20th tab. From Moody's. Page 1 of 10.
I have it.
Again, we're talking about this HB 951, which I'll represent to you is the name of the law that we're here about. And again, it's behind tab 1 if you'd like to review it. But this document behind Moody's, I would propose to mark as public staff cross-examination, Moran, direct and rebuttal, Exhibit 15.
All right, document will be marked as public staff cross-examination, more and direct rebuttal, exhibit number 15.
Subject to, I'm going to read the sort of last paragraph on the page. I'm going to read from the middle. Subject to efficient implementation by the NCUC, a multi-year framework with performance-based incentives would be credit positive for Duke Energy progress because it would provide greater revenue visibility and reduce regulatory lag in a state where electric utilities do not benefit from tracking mechanisms.
Again, I totally agree.
Okay.
It's a good thing because it's offsetting all these other risks.
I mean, I just think you're trying to shorten my examination of you, but okay.
Imagine if you didn't have it and everybody else did, what would happen?
So let's talk about the point you've been making repeatedly. Let's look at tab 10, which I would propose to mark public staff cross-examination, Moran, direct and rebuttal, Exhibit 16.
All right, document will be so marked.
Have it.
RRA again. And this is a document by RRA surveying the 50 states for adjustment clauses. And if we can just turn for a moment to page 5 of 31. But I'm not trying to rush you, Doctor, if you'd like to spend more time.
I'm there.
Okay, 5 of 31, the take. Do you see that sort of shaded portion? That shading's by RRA, not by Will Freeman. I'm going to read the second sentence. A defining characteristic of an adjustment clause is that it effectively shifts the risk associated with recovery of an expense from shareholders to customers.
Yes,
Is that a true statement?
I believe so.
Okay. I just want to glance with you at page 4 of 31. And what RRA does here, and we're going to look at it just in a little bit more detail in a minute, but what they've done is they've said there's not just one adjustment clause, there's lots of them. And I think we've heard that from both from you and the first panel here. There was that sort of, you see here, the transmission costs. I think Witness Bowman told us there was that neat little thing they had in Indiana where you could get transmission costs. We got 81% of the states have fuel, 70% have conservation, and so on. RRA says only half the state, 56%. Only half the states, 56%, a little bit more than half, have decoupling.
Correct, but they have other mechanisms that accomplish the same goal.
I understand. I don't see any of these numbers at 100%. They're all high, and then some of them are lower than others. But decoupling is right in the middle at 56%.
But if you take the whole shebang as a whole, PBR, MYRP, PIM, decoupling, the whole package, I think that's 100%.
So if you'll just turn with me just so we can, and I want to talk about that in just one second, but look on page 6 of 31. You see what they've done here is they've listed all the states down the left and the companies that are electric within those states, and then at the top, the different kind of mechanisms. Have you created a chart like this for us to review for the companies in your proxy group?
I didn't have to, it's right here.
Okay, great. Have you summarized this for us so that we can say which ones are the ones in your proxy group? And this is electric. Your proxy group, I know, has companies that have a lot of gas in them. But just for the electric, if we hived out that, could we create a chart like this for your companies in the proxy group? Which incidentally we used in our proxy group too, right?
Yeah, they operate, the epoxy group companies all operate in these states.
Okay.
And more than one state in many cases. So this would apply to the peer group.
So
my peer group is a proxy for the industry.
But you're telling me, I know your statement is when you add them all up, they're pretty much all about the same, right?
Yeah, they reduce regulatory lag and volatility of revenues and streamline regulation, which is a good thing.
And I hear you saying that general statement, but I don't have a specific document from you saying, here's the 12 mechanisms, and here's the ones that have them, and here's the impact, right?
Here it is, right here.
Okay. So I would like to go through this document, and you see where it says decoupling full?
Yep.
What I'd like to do is go through it and see where RRA has checked full decoupling. And I will save us some time if you will turn to tab 11, which I would propose to mark as Public Staff Cross-Examination Morin, Direct and Rebuttal Exhibit 17.
All right, I just want to make sure I'm looking at the right document here. It's a map of the United States. All right, document will be marked as Public Staff Cross-Examination Morin Direct Rebuttal Exhibit number 17.
Do you have a source for this document?
Yes, it's the exhibits, the tab immediately before.
Okay.
I just went through where they had checked full and put in the states that had quote unquote full decoupling per RRA. And it's not many.
That's correct. But if you check PBR and if you check riders and trackers and other mechanisms, the map would be full.
Have you done that?
No, I didn't have to. It's in that report that you just confronted me with.
So until today, you didn't have this report or this information?
I quoted, I referenced it in my rebuttal.
Okay. You could have made a map with the proxy groups and presented to this commission, but haven't. Is that correct?
That's correct, because I didn't have to.
Okay. I'd like to talk with you now about the document behind tab 12, which I would propose to mark as Public Staff Cross-Examination Morin Direct and Rebuttal Exhibit 18.
All right, document will be so marked.
And this is a document Now, this is from 2020. So we're 3 years old, 2020. And this is a document that explores multi-year, which is not addressed in the RRA report on adjustment clauses. You see the difference?
Yes.
Okay. And I did the same thing before. I went through the multi-year column and everywhere a state was checked. I made a map. If we could turn to the next tab, which is 13, I proposed to mark the document behind tab 13, the map of the United States, public staff cross-examination, more indirect and rebuttal, exhibit 19.
Yeah, I agree with that. I don't have a problem with it at all, but if you did it for all the risk mitigators, the map would be all yellow.
We'll do it then. Let's do it. Make that and submit it as a late filed exhibit. It's one thing to just say in the ether, yeah, these are all about the same. I mean, I went through and did it. Here's every single one that has it. There's every single one that has it, but you haven't done that, have you?
I didn't have to. Somebody's done it. A rather pretty good job and comprehensive review of all the states and all the mechanism. It's there.
I understand. I would like to I'd like to, if I could have just one moment, Dr.
Oh, sure.
Could I have just one moment, Commissioners? I am close to finishing. Are you familiar with the fact that there is inflation protection through this multi-year plan?
No, not really. Company
You don't
witness.
know one way or the other, and I should ask someone else.
I think you should ask somebody else.
Okay. Just one more moment, and I may be. I think that let me paraphrase your argument. Everybody's got some kind of various risk mitigation law rider item.
Correct.
So it's kind of baked in to the ROE of your proxy group.
I like that term, baked in.
Thank you.
So-
If we quantify for it, what is the percentage that results from all these risks? What the ROEs have this all baked in. Tell me what the number is that is baked in.
That's a tough one. Just based on judgment and experience, it would be something of the order of 25 basis points.
Okay.
That's the best opinion I can offer you.
Okay.
If you didn't have it, the ROE would be that much higher.
Thank you.
That's another way of putting it.
Dr. Moran, I very much appreciate your time. The public staff does not have any more questions.
Thank you. I appreciate your cross.
All right, at this point, we've come to the end of our day. We will be back on the record in the morning at 9 o'clock, and we will begin with redirect of Dr. Moran. We are off the record. Thank you very much.